Yay.
Thank you. This is the council meeting of February 8th, 2023. Larkspur City Council has taken roll already and all council members are present. They've also taken general public comment under item 2.
Great. Thank you. And thank you for the technical staff. And again, all of you online, we really appreciate your patience. We were stalling here, just trying to get an audio and a video connection. We want to hear from you. We didn't want to move forward. So what I want to do then is we just took on our agenda, item number 2 is public comment. And those are for items not on the agenda tonight, which of course is just cause eviction. So we took one comment from Ilana Scott here in the room. And if anyone out there wants to make public comments that's not on tonight's agenda, please raise your hand.
And I'm looking for any raised hands from our audience members for general public comment. Our first commenter is Angela Mercado.
Okay, welcome, Angela.
And Angela, I'll ask you to unmute.
Thank you. Am I unmuted?
Yes.
Okay. So we are commenting on the just cause evictions, correct?
No, ma'am. That's the next business item. So anything that's not that is what this time is reserved for.
Okay, so that's what I want to speak on. So I'll wait.
Okay, no problem. See if there's anyone else.
And there's no public comment.
Okay, great. So then let's move on to business item 3. And I believe City Manager, you have a staff report or presentation or both.
Thank you, Mr. Mayor, council members. This evening, the council scheduled this special meeting and this workshop to have a forum where you can discuss in general terms the concept of eviction protections and receive public input. The council at its last meeting on the subject of rent regulation, eviction protections, and other issues instructed staff to separate these two discussions, but keep them on parallel tracks. So ultimately that we can come back together should we so desire to take them all up toward the end of your deliberations. But the reason for separating them was it was our impression that this particular topic was not getting necessarily the attention it warrants in terms of its own implications if the council is to choose to act under to modify and adopt an ordinance that modifies eviction protections. So that's why we scheduled this meeting that's limited to that topic. With that, I have a short presentation to sort of provide an overview of the topic, which is also in the staff report. I've added a little more detail here and tried to summarize things a bit. So as a reminder, the same statement about rent stabilization applies to eviction protections. They exist in Larkspur today. There is state law, the Tenant Protection Act, and it does encompass not only rent stabilization, but provides for eviction protections. That said, some jurisdictions are electing to take the framework in the state law and enhance it or modify it to suit their community. And a reminder, when you look at state law, you can always make local ordinances stronger than state law. You can't make them weaker than state law. So when I talk about modifications or enhancements, it's to strengthen this particular area of law relative to what the state has produced. So it's probably helpful to remind ourselves what the Tenant Protection Act says with respect to eviction protections. And so we've provided you in the PowerPoint a reminder of what that is. So first, it prohibits a landlord from terminating a month-to-month tenancy, and it also prohibits a landlord from choosing not to renew a fixed term lease without providing a just cause for termination. And in the report, we provided you what the list of the just causes are. We'll be talking about that more this evening. The Tenant Protection Act applies to both termination and non-renewal when either all the tenants have continuously and lawfully occupied the unit for 12 months or more, or when one or more tenants in the unit has continuously and lawfully occupied the unit for 24 months or more. In addition, the act provides, the act divides just cause in terms of evictions, just cause into two categories, at fault and no fault. And those are enumerated in the staff report. You can summarize the at fault as essentially the tenant has violated the law or they've violated the lease. And that would be the fault of the tenant. The tenant had the choice to not be at fault, but they are at fault and they're subject to the consequence of potentially of eviction. No fault is the category where it is not some action of the tenant that has given the landlord reason to have to start an eviction process. Hence the name. It's not the fault of the tenant. The Tenant Protection Act requires a landlord who terminates the tenancy based on a no-fault cause to provide relocation assistance to the displaced tenant in an amount equal to 1 month's rent, unless a court or government agency determines that the tenant caused the condition requiring the vacancy. So essentially, the four no-fault causes that we're going to be talking about, I suspect, this evening as the focus point. If they're invoked, then you have to compensate the tenant with 1 month's, the equivalent of 1 month's rent. And then the act also provides that tenants have a 3-day opportunity to remedy a curable lease violation. So from time to time, tenants inadvertently violate their lease and they have to be given an opportunity to fix the violation if it's fixable. So that's what that provision's about. Oh, it looks like I accidentally I'm stuck in a loop. Okay, here we go. There are exemptions in the Tenant Protection Act. And one of the things you can talk about, one of the things you may hear about from speakers this evening is that you can strengthen state law by removing some of these exemptions. I think if you've been following the press about another jurisdiction in Marin, this is what a lot of the discussion has been about, is the decision of that jurisdiction to remove some of these exemptions. In particular, I think where there's been, as I've been monitoring it, a lot of discussion is on the last two exemptions. If you're renting out a single family home or you're renting out an ADU. As you'll see, if you read through these exemptions, some of them make a lot of sense. Hotels and transient occupancy locations aren't really what the council is driving at when you're talking about displacement. But a lot of these other ones are about situations where the owner is probably also residing on the property. And those are almost all exempted under the act.
Sorry, before you go on, can you just address the one that says housing that has been issued a certificate of occupancy within the last 15 years?
Yeah, thank you. That's probably one I should have highlighted. There's an interesting component to the Tenant Protection Act that it has this rolling part of this exemption here. So that's essentially a way of saying anything that was newly constructed. Although on some occasions, remodel has to be vacated and then receive a new certificate of occupancy. So that might be triggered here as well. But essentially what the law is saying is anything that came online in the last 15 years is exempt from the Tenant Protection Act's eviction protections.
And as a follow, sorry, go ahead, Scott. Yeah, as a follow-up question, is that Costa-Hawkins?
No,
Okay.
this is explicitly this act.
Okay.
And that's why the unique provision here is that it says the last 15 years, and this is a 10-year act. So it's a rolling exemption. There are going to be units that are exempt, that were exempt when the act was passed, but are going to not be exempt if they are older than 15 years.
Understood.
So, and I'm sorry, just if I could just follow up, it sounds like, and I don't know if you can comment on this, the intention is that when a unit comes on the market, it is put at market rate. It allows a unit, I guess, 15 years for market rate rent, maybe for return of investment or whatever it happens to be, before this kicks in. Is that accurate?
I am totally in speculation land, but I think it was probably to address the concern that these eviction protections don't act as a deterrent to somebody doing new construction.
Okay, thank you.
Okay, as I said, I don't think our intention here this evening is to focus on at fault just cause evictions. I think our intention is to discuss no fault evictions. And so we want to focus on the 4 that are identified in the act. So the 4 that are identified in the act, the first one is that the landlord or member of their family wish to move into the unit, to occupy the unit. The next one is the landlord withdraws the rental unit from the market as per the Ellis Act, which is an act that protects a landlord's right to do that very thing. The third category is an order's been issued by a court or government agency requiring vacating of the unit. And then lastly, the landlord wishes to demolish or substantially remodel the unit. And under the act, it talks about if the construction is going to take 30 days or more, that constitutes something substantial. Or it's, at least it's implied the way you read the act. When you look around and you see what different communities are doing, I'm having the darndest time with this, Allison. Can you advance it for me? Thank you. You find that in general, the discussion, the debate, and the ordinances that are adopting locally concentrate heavily on the 2 that are highlighted, the first and the last. So a situation where the landlord is initiating an eviction because they want to occupy the unit, or they want to do the remodel or demolish. It's not that the others aren't part of the package, and we'll be talking about them, but these 2 get a lot of the focus, and it's understandable because these are the ones that, as I read sort of what's happening out there, these are the ones that are probably used most frequently.
Do they have to occupy the unit as a full-time residence, or can they occupy the unit as a part-time, let's say, vacation residence or something? I just wondered if they have to establish full-time residency.
I don't think the statute specifies. And because the statute remains relatively new, there isn't any published case law that addresses this issue. There may well be some trial court decisions that have delved into it, but I'm not aware of the outcome of those cases.
Okay.
Yeah, I'm sorry, one more follow-up question. Is there a period of time of which the property owner must live in the unit before they re-rent it? I mean, can I
So
take somebody
so
out, live there
that's
for
coming.
3 days and then
That's
re-rent
coming.
it? Okay.
That's coming. We'll talk about that one a little bit.
Okay.
Yeah. We'll try to look up Councilmember Way and see what cities have done in
Yeah.
response to your question. It would not surprise me that some of the local ordinances get to the level of detail of full-time occupancy versus part-time occupancy. But my recollection is that the statute is silent on the point. Okay, so what might you be talking about this evening and as you go forward when you think about these things? And this is not an exhaustive list. In your packet, I should note, we gave you just 2 examples because I could bombard you with a lot of examples, but I try to give you what I thought were 2 of the most on the very extreme to kind of define your range. So you have Concords, which is pretty simplistic on one extreme, and you've got Fairfax, which is fairly comprehensive on the other extreme. That kind of, my intention was just give you a breadth of, it's a pretty wide open arena for you in terms of policymaking. Provided you can make the justification for the things you want to enact. With that said, and before I go through some of the key things you might want to focus on, you should bear in mind that we also have examples in the state where eviction under these 4 provisions has been made so onerous, it's essentially created a market where the tenant can seek a fee from the landlord to move out. And so one of the questions you'll have to think about if you were to try to create something on that level is whether you want to engender that sort of behavior or not. Okay, with that said, these are some of the ones I see consistently, questions that you may want to be talking about among yourselves or with the community. First, how much should a tenant be compensated if they're subject to a no-fault eviction? The statute's 1 month. Other jurisdictions have done higher levels of compensation than that. So that's a question and a debate that you may want to engage in or hear from the public this evening and going forward. The other is timing. Some jurisdictions try to put in some restrictions about when evictions can take place. I particularly highlighted in the staff report one that I've seen in some of the language, which is around the idea of not evicting certain populations like school children during the school year, since that's identified as something that's extraordinarily disruptive. So if the landlord's aware they have school-age children in the unit, then they have to plan the no-fault eviction around the school year. That's what we mean by timing, and there are some other examples that we can present to you going forward of other populations that should be considered. This goes to the one Vice Mayor Candell was asking about, and that's the right of return. So the right of return is the concept that if I was subject to a no-fault eviction and then the conditions for which I was evicted no longer exist, do I have the first right to have the unit back? And there's nuances to that question. How long should the right of return exist? Should it be for a certain specified time period, or should it be for a long duration? And that's, you see different examples in different ordinances of time periods, although usually you see it 6 months or a year. There's also a question of what you pay upon return. Most of the ordinances that I've seen talk about paying what you paid before, but one of the questions becomes, if there's been a substantial investment in the unit in the time you've departed, how is that, or is that accounted for? And that's a discussion that you may need to have. Another right that you see in a lot of the local ordinances is the right to an available alternative. And so this is the idea that if the landlord has other units and some of those units are vacant and available to be rented, should the landlord be required to offer the tenant who's subject to eviction the option of moving into one of the available units? So you'll see that provision.
Can I ask a question about that one part? So that would obviously affect bigger property owners and smaller property owners. If somebody has a 4-unit, building, it seems much less likely that they're going to have an available unit than somebody who has a 500-unit building. Is there any issues, equal protection issues, that it's affecting one owner more than another owner?
I don't believe there'd be an equal protection issue, just because the basis for it is not one that's a protected category. So it would just be rational basis review. And I think that treating them the same would be, there'd be a reasonable government justification for it, in that that it's a tenant protection provision, and the size of the number of units that the property owner has is irrelevant to whether or not they have one available. And as long as they have one available, all property owners are being treated the same way.
Okay, thank you.
The other thing I'd add is usually the way the language is crafted in these ordinances, it's designed to recognize that some landlords own more than one property and inside their jurisdiction. And so they're often crafted that if you have an available unit somewhere in the jurisdiction, you have to make it available to the tenant. So, and the next question, because every one of these things will create nuanced follow-up questions. So the next one will be, is it made available at the current offering rent or at the rent that the tenant's paying in their current occupancy? And that's something that if we are going down the path, we would have to discuss and decide. So,
Mr. Mayor, can I just interrupt and ask a couple questions on this slide? First of all, it's an linguistic issue. On the number, so your second bullet, it says some local regulations restrict when no fault evictions can be enacted. Is the word enact, is that a word you
Oh,
really want to use?
no, probably, right?
I mean, when an eviction is conducted or something like that.
Fair.
Just to be clear, that kind of confused me. On more substantively, on the last bullet item, right to available alternative. How is the issue of whether an available alternative is or is not comparable to the unit that's being vacated, and whether that's required in ordinance that have been enacted to be taken into account?
I'd need more time to research that. In the ones I've read, I haven't seen a lot of attention paid to that particular question.
Okay, because it could be that a landlord could say, well, there's an available alternative, but it's a piece of junk. You know, it's terrible, it's uninhabitable, but it's available. And you know, here you go.
Might not
And
be the best sales pitch, but
yeah, no, well, right. But I guess that unless there's some parameters placed around what the condition of that available alternative might be, I think that would need to be clarified.
yeah, I would say based on a few of them I've looked at, I think if the extreme cases, I only have one thing available, it may not be something that interests you, but I have it available. That's one scenario, but I think the intent I read in the ordinance I've looked at is if you have multiple available options, then you engage with the tenant on which one they're gonna.
I think the more common occurrence would be if somebody's renting a 3-bedroom and only a studio is available. Does the landlord have to offer the studio?
My read of most of the ordinances is they do have to offer it.
And it's up to the tenant to
Yeah,
decide.
I think
But
in the
hang
scenario
on.
Councilmember Harf's talking about, the quality or condition isn't really addressed.
Right, but what about the opposite? If someone was renting a studio and the only thing available was a 3-bedroom, do they have to offer that at the same price?
And now we're into the challenge
Wait,
with
yes.
legislation, right? You have to
Right.
start thinking through all these scenarios.
Yeah, I mean, these are issues that
But
language triggers.
well, and I'm only offering this to you because I
Right.
think there is a tendency, I mentioned this before, there's a tendency in these discussions to focus on rent caps and not spend a little more time on these eviction protections. And I actually think these questions you're asking are the nuances that result in a lot of unintended consequences. And so I think it was a good decision by the council to put this on a separate discussion track so that we're not rushing to do anything here without having tried to think through some of these things. And there are people, we don't have to reinvent the wheel. There's a lot of
Right.
examples out there once you start kind of getting a sense where the public wants to be and where you want to go.
And I know all along in this process, data collection has been difficult since there is very little data to collect as far as a recognizable database. But are we familiar with any situations in which a no fault eviction has been taking place here within our jurisdiction at numbers that?
We don't have that kind of data at our disposal. And I don't know that the data I do have at my disposal for Larkspur could do anything other than tell me an eviction took place. I'd have to coordinate with the police and the sheriff because they're usually called out. That's actually how we tally and know evictions that have occurred, is because usually the landlord requests the presence of law enforcement. So although I think a lot of times if it's been worked out contractually, law enforcement's not involved, and we wouldn't have any knowledge of those evictions.
And then when it says demolition or substantial remodel of the unit, what if they the demolition or substantial remodel is of the entire complex, then it requires every unit to move out and all these apply.
Yeah, but each one's an eviction. You can't do one eviction for the whole building. You have to evict each tenant.
Each tenant. Okay.
So that's why the language focuses on individual tenants and individual units.
Right. Just one more about the substantial remodel lists 30 days to 60 days. I don't know anybody who can get a remodel done in 30 days to 60 days. So what are the implications if that remodel part lasts for a year or two? They continue to have the landlord then continues to have to engage in that opportunity to rent another unit to the tenant. Is that right? Sky's shaking his head. So generally,
Again, the part of this is how you
yeah.
want the ordinance crafted. So if you want to put an end time to some of these rights, you can do that too, right? So if you said the right of return or the right to an alternative exists for a year, that's something you could do. And so as you go through this discussion, if you elect to move down the path of crafting an ordinance with or direct staff to start that process, we'll start to ask you these questions. Do you want to have that? But I think we're so far from that now. We're still kind of trying to be more up at the 10,000 foot level of, do we want to do this? And if we do, what are some rough parameters of what we're trying to accomplish? The other thing I want to emphasize is that although I keep telling you that as I watch these things and I've researched them, most communities take up both these questions at the same time. Legally, you could do one or the other, and you don't need to do them both. And particularly because you have state law, they are provided for. So you could decide to proceed down the path of only doing rent stabilization or some other rent regulation, or you might decide to not pursue that, but you might decide eviction protections need strengthening. So you have those options available to you. That's the end of my presentation. And
Okay, any other council member? Yeah.
Yeah, I have a
Councilmember
couple
Kerr.
of questions.
Sure.
I don't know, if there's an answer to this too, but I know the hot button issue on the property ownership. It states that a single family residence or condo unless owned by a real estate trust corporation or LLC where one member is a corporation. How would that apply in a case of a family setting up a trust for their parents and or a conservancy on the parent? What happens? What's defined? How does that fall?
And I
under
see
the legal
Sky's going
ownership?
to look what the
I
statute
see his
says. I
finger
know the
flying.
intent of that language, so I suspect it's addressed in the statute, but real estate
But it's
investment,
something we could,
real estate
exempt.
investment trusts, though, we're purchasing tracts of single family homes in parts of Southern California. And so during the crafting of the Tenant Protection Act, there was a specific request to address that issue. And so that language was intended to target that particular situation.
well, people are getting very creative nowadays beyond the law. They're a little ahead of the law, I think, sometimes in setting up some of these trusts.
Yes, but I think that's correct. But I guess I'd say in the typical situation in which a family is doing what we normally expect families to do, where they're setting up a living trust to hold the real property or setting up a conservancy, under AB 1482, those types of trusts are just not included in this exemption. It really does refer to a real estate trust or an LLC where a corporation is a member of either of those two entities. As city manager has been emphasizing, if the city council chooses to head down the path of crafting local legislation to address this, if you wanted to expand the type of expand or narrow the types of trusts or corporate entities that would qualify for an exemption like that, you'd have the ability to do that to try to capture some of the more complicated ones. But to your point, if we have a decent sense of where things are at the time that the ordinance is drafted, we may have to revisit it in a couple of years if we find that new types of corporate entities are being set up to hold property. And we just have to amend the ordinance to capture those as well.
Yeah, and there could be changes in tax law that make other things more advantageous, et cetera. Okay. The other thing is just a comment that on whether a landlord is a resident of when they take over a unit. Most of the ordinances I've read require that the landlord register their vehicle, have their driver's license, et cetera, tied to that specific address. So that's a way of proof that they are actually living there. That's one of the proofs that they require. That other questions? Well, here we are. What about getting to withdrawal from the market based on an order issued by a court or government agency to vacate? I'm assuming an agency would be something like the health department saying you have a mold problem that has to be remedied immediately, or an asbestos problem that has to be remedied immediately. What about if the landlord is voluntarily doing it without a court or an agency order? They're saying, I think it's a health hazard and I have to take care of this now. How does that fall under?
The type of exception that's in 1482 and that other local jurisdictions have adopted require a government. It does not allow for the owner to do it unless it then also falls essentially under the remodel, where they're voluntarily taking action to make some modifications to the unit, and then those provisions of the ordinance would apply. For the ones where there's an exemption, it requires an outside government agency to order an eviction. Another example would be the Larkspur building department determining that there's a habitability issue and the unit has to be quote unquote red tagged and the tenant has to vacate. But that's also a situation in which some, also getting into some of the complications of this, some cities have adopted ordinances to say that if the habitability issue is the result of negligence or inaction or actions by the property owner, then a separate relocation reimbursement provision would apply, because then they're causing the habitability issue to occur.
Okay. And usually, yeah, those orders come from the county, right? Not from our city.
Yeah.
It depends. There are circumstances where our building department might determine it's something structurally unsafe and red tag it.
But what about environmental issues? I mean, isn't that generally done?
We don't typically do inspections for environmental issues unless we're called in by somebody to take a look. We would almost, in your mold example, for example, we would work in partnership with the county if that's the particular problem we found. But there are certainly a number of circumstances where our building folks have had to red tag something as not being safe to occupy. Oftentimes it's after some external force has affected this
Fire,
the structural soundness
hit
of
by
a
a
building.
truck or something.
Yeah, all sorts of things could result in a red tag. So it could be us.
Okay. Thank you.
Okay, any other questions of any council members? No, okay. So what I'd like to, yes.
Chris, I think I know the answer. We don't have any properties within Larkspur's jurisdiction that are owned and operated by the Marin Housing Authority, do we?
So a lot of times what the housing authority does is they partner with a nonprofit that actually runs the operation. So we do have properties in Larkspur that the underlying contract is with the housing.
With the housing authority.
Yeah.
So
But they're not the operator. They're not the property manager.
who would be the landlord in that case?
Yeah.
It depends on which property we're talking about. It'd be the entity that's property manager. The way they've structured the contracts, they're essentially the funding agency. They help make the deal happen.
Okay.
But we actually do for at least one of our properties, we get annual reports from the housing authority about what's happening at that property. So,
Is that because they're managing it?
It's required in the agreement that was crafted when it was built. So we get these periodic, and we get these annual updates from them that they're required to provide. I assume it dates all the way back to whichever pot of grant money got taken initially to do the project.
A good example is Edgewater Court.
Mhm.
Is,
LTH.
Yeah.
and it gets inspected annually by the county housing department and a report's issued.
Right, I guess I'm going more to the question is, under circumstances where the housing authority is involved, whether there is another entity that's doing the management operation of the facility, who's the landlord, who would be treated as the entity that would be subject to these
It's important to
requirements?
remember all those, they're all exempt from. All the affordable housing is exempt, so it's not an issue. So,
Okay,
right, because they're all governed by rules on when they can and can't evict their tenants.
Right.
That are different from this body of law. So,
okay, and that doesn't need to be made specific in the context of our ordinance that's recognized to be. the
we would
case.
absorb language straight out of state law that says these are all exempt, or we'd reference the state law to remind folks that there's a body of institutions that are exempt.
Okay. Okay, I'm thinking of other places elsewhere, elsewhere in Marin where Marin Housing Authority is a much bigger
Yeah,
landlord.
I'd have to go back and check the exact number, but it's 300, 400 units in Larkspur. It's a pretty sizable number.
Okay, so let's move forward. I wanted to get to public comment, but I had a few opening remarks. I really wanted to make sure tonight is as productive as possible and really, gets us closer to a decision. So I wrote down here four or five comments, and they're very brief. Won't take me more than a few minutes. And my first is I just want to thank everyone here in the audience and everyone who's on Zoom for, to this point, and we've been discussing this for months, for being, I think, very respectful. And I think the stakes are high, and I appreciate it's emotional. And I also think people have done a great job of listening and maintaining decorum and civility. And why I think that's important too is we as council members, we realize how important this is, and we want to do the right thing, and we need to hear from everybody. And that also means we need to feel that everybody who's here feels safe, that they're not going to be heckled, that there's an applause or snapping or jeering or whatever. So I'll be pretty strict tonight. I really want to make sure that we continue that, because that to me is going to let this, be a productive conversation, and all voices are important here tonight. My second point is I have a suggestion how to make public comment more helpful, and I'm going to bounce this off my council members for just a minute. I'm wondering if, perhaps the council members, I'll start with myself, to tell you, the audience, to be transparent with you, what might help us make our decision. So if you come up here, there are a lot of, personal stories, there are a lot of details, but I think you're probably interested in seeing us move towards a decision. So for me personally, if you're a renter, I would be interested in seeing in what part of no fault just cause protections in 1482 are inadequate and why. Maybe you can give me some specific examples. And if you're an owner, I'd be interested in hearing, what no fault just cause protections that we might add or change in 1482 would become onerous or burdensome or getting in the way of business, and why. And I don't really want to deal in hypotheticals. I mean, this is me personally. It'd be more helpful for me to move my decision making if it's not hypothetical, but something that you've experienced or seen, or it's actual. We don't know where the economy is going to go and so forth. So I don't know if any of the other council members want to state, again, the point is you guys want to be heard, but you also want to make a change and make a difference. So I'm trying to start this meeting off by saying, for me at least, these are the things that will help me. A lot of things I've heard over and over, and I've listened to other meetings, and I'm not sure they'll move the needle. So maybe Councilmember Way.
I think that, what are your other two?
Those were my two. Yeah.
Four.
Well, I have two more points after this. So.
I think that will definitely help. And I think it would also help if the comment tonight in audience and on Zoom, and we have a lot of letters, was specific to this, to the just cause eviction and not to rent control, because that's a separate piece that we're navigating with a lot of comment, and a lot of discussion in different contexts than tonight.
Councilmember Harrell.
I just want to reiterate what Councilmember Wade just said, because it is easy to conflate the two issues, which we've done to some extent ourselves over
Yeah.
time. But I would encourage the mayor, if it appears that public comment is going in a direction that does in fact conflate those two issues, that the mayor points that out and make sure that we move along. Because it's very easy to get distracted when these issues merge.
Fair enough. So what I'm hearing is we're here to talk about just cause, not rent caps. And so we'll stick with that and I'll try to keep us on track. Councilmember.
And I'm sorry, the only thing, and I'm just speaking for myself right now, is that for me, it is the idea that matters more than the number of people that repeat an idea. I am here to learn and to hear different perspectives and to hear different logic. And if only one person says something and I find it compelling, that will have just as much weight to me as if 10 people say the same thing. So I know everybody wants to be heard, but I'm just saying for my decision making, the more unique things I hear, if somebody has something to say, I would love to consider it and everything like that. But if you're saying the same thing that other people have said, I understand you want to be heard. You may just, if you want to say, hey, I agree with what that person said. But for me personally, I just don't need to hear the whole thing over again if you're going to say the same thing. That's all. Thank you.
Thank you. Councilmember Carroll.
I agree to a degree with all of my fellow council members. They're making important points as far as to what you present tonight. I can say personally, and I assume it's true for my fellow members, we've read all the written comments. So repeating them is not going to do much except take up time that maybe someone else needs. As far as the comments, I would prefer that particularly from both sides, that they refer to Larkspur, particularly from the landlords. I've done a lot of research on my own about other areas, what's publicly available, and not much registers about Larkspur landowners because we're not as big a community as some of the others. And I don't think in reading the comments from some landlords and from what's in the IJ and whatever, they talk about situations that just don't apply to Larkspur physically. It's just, we don't have those conditions. And so I appreciate it if the comments are on our situation here. Thank you.
Great, thank you. And so 2 more points. One is another thing that might help us move this process along is to give the council members some time to talk and debate and argue in public, because there's differences of opinion here. And as you know, by the Brown Act, for example, council member Way and Candell are dealing with rental subsidies, and Councilmember Haroff and I are dealing with rent caps, and we don't know what's going on. We do want to stick with just cause eviction, but nonetheless, we can't talk offline, by the Brown Act with more than one other council member. So the balance and the judgment call I'm looking for is, I know you guys came tonight. I see 5 raised hands. There are many, many more people in Zoom, and there are potentially 35 or 40 public comments tonight. Let's make sure, and we'll see as time goes on, that we get everybody to say what they need to say and be heard. But I want to reserve some time for the council to actually hash things out more, because I think those of you who are waiting for a decision, it's really going to serve you more. And we found this at our January 31st workshop, that once we started talking amongst each other, there was a lot more movement in the sense that, we're going to make a decision. So I ask for you to, we'll probably know in about an hour kind of where to strike the balance. Councilmember.
Mr.
yeah.
Mayor, I'd really like the record to reflect that no substantive conversation about this issue or rent stabilization took place on January 31st. Only the council's commitment to trying to move forward in an expeditious manner. That was the extent of the substance of conversation. So
Yes, yeah, point well taken. I think we talked about, many issues of operations, but we left the last 5 or 10 minutes and we realized that we haven't talked enough, and I wanted to make that, point public. My last point is lots of the public comment was about whom we invited, and I'm a big believer in inclusion and that everybody who wants to speak can speak. If you ever email me, just try me. I will always respond. I'm holding office hours. I thought the city manager might give us, some understanding as to how we send out the invites and how we're trying to involve the community as much as possible.
yeah, so the city has an adopted communications program and has 2 staff who among their primary duties are communication. The city relies primarily on electronic communication to do outreach and to make awareness in the community, to generate awareness in the community of the issues that the council's discussing. From time to time, we recognize and observe through the presence in the chamber and the presence in our Zoom meetings that we're not reaching a particular cohort that the council has interest in hearing from. At the last meeting that we had on this topic, one of the things that was stated was that concern that the landlord community was actually getting the message that this was occurring. And so to supplement our existing communications program, which I think has empirically demonstrated that you're generating a representation of the tenant voice. We sent the exact language that we've been posting online by US mail to a list of landlords that's available to us, which is, to the best of my knowledge, all of them, but I don't actually know that every single family home is on that list. So it was the exact same language. There was nothing special about it. I suppose next time I won't try to be charming and write, "You're invited," because that I've seen enough of the online chatter to think that apparently caused its own consternation. Next time I'll just say, "Hey, there's a meeting going on. Maybe you want to come," or something like that. But there's nothing different other than it was on a piece of paper and a stamp got put on it and it got dropped in a mailbox. By our estimate, the people who got the mail got it probably 24 hours before the first electronic notice was made. So to the extent that was an advantage, we did create a 24-hour window where folks got it in the US mail potentially, depending on when they got their US mail.
Okay, thank you. Okay, so with that, I'd like to start with public comment, and we were half an hour late starting the meeting, but you all have been very patient. We want to hear from everybody. I think we'll start with the 3-minute limit, but please mind what we said. We're really trying to learn from you here tonight. So with that, is anybody in the chamber want to make public comment?
Mr. Mayor, I'm sorry, did you want to have a timer this evening, or do you want me?
Yes, and let's start with the 3 minutes, and if we go, we'll see just how many hands there are. I think we need to leave some time, and we are late. Well, please just go up to the mic and tell us your name and where you're from.
Okay, my name is Gila Faley, and obviously I'm a resident in Larkspur. I'm actually I'm representing myself, not the whole community, but I'm a landlord. So I wanted to talk to you about that. So I was, looking at the no fault just cause, which is in question tonight. And I just wanted to say that to me as a landlord, it seems fair that if any of these cases happen, then we have to help to relocate the tenant. And I think that's a fair decision, as it is already stated in the state laws. The reason why I'm saying that is because personally, my husband and I actually own a triplex in Larkspur. So it's a very small, property. And one of these is a 1-bedroom. And I also have, my mom is in she's in late 80s, about 87 years old. And she lives by herself in the South Bay. And thankfully, she can be by herself and independent, but her health is failing. And I'm thinking that in the near future, I don't know when, but it might be the situation that she has to move closer to me. And since we already have this property that has a 1-bedroom that accommodates her, I think I should have a option of giving notice that, my mother is, moving to one of those units. And obviously we have to compensate the tenant to move out to a new location. And the second, another item is about if you want to take it off the market. Again, our financial situation could change at any moment, which means that we have to sell the property, which means it has to be off the market for rental. And therefore we have to give notice because we've, I don't know how hard it's going to be to sell the property if there are tenants there. So we might have to give notice to them to move out and put it back on the market. So I think being able to accommodate tenants to move out and help them with that, I think that's fair as a landlord. Thank you very much for listening to me.
Great. Thank you for your comment. Okay, anybody else here in the chamber? We can always come back if you want to. Doesn't look like anyone's rushing to the mic. Oh, go ahead. Go. Don't be bashful.
I don't want this to be too loud, but okay. Good evening. Thank you, Mayor Polson and City Council. My name is Angelina Soldatos, and I'm with the California Apartment Association. I will be respectful of what was requested tonight. So I will be addressing the evictions under AB 1482. And I would like to remind council, because the subject of data was brought up tonight, that in 2020, AB 1482 was enacted. However, 75 days later, COVID-19 pandemic affected us all. And during this time, there was a wave of eviction moratoria throughout the state, some of which were lasting 2.5 years and are still going on right now. We will not have efficient data. So we need to allow 1482 to actually go into effect and work before we add more measures or ordinances on top of it. Thank you so much.
Thank you, Angelina. Okay, who wants to go next?
Hi there. Can you hear me?
Mhm.
Okay. My name is Ann Clark from Larkspur Courts.
Mhm.
I wanted to talk about one of the reasons of the no fault just cause, the demolition or substantial remodel of the unit. This is a gaping loophole with no full detailed description of what a substantial remodel of the unit entails. Is it just a regular apartment turnover, which is usually, you can get it down to 1 day to 3 days. This is done when a resident moves out, and maybe with possible changing of appliances and light fixtures, which does necessitate this while the tenant is there. Because these changes can be done while the resident is inhabiting, forget it. But if they are gutting the kitchen and the bathroom completely down to the plasterboards and the studs, then this will require the tenant and resident to be transferred, relocated within the complex or to a hotel, motel, or extended stay. And in the past, used to be a property manager. This was at the expense of the owner / landlord. And now I feel that it should be written that there's a right, of alternatives, relocated, transferred within a complex or hotels, extended stay, right of return, and right of compensation. In the remodel of gutting it down to the kitchen and bathroom, you can do a turn like that within, 4 to 6 weeks. You can even cut it down further than that, and it has been done. I've seen it done. And the other, one of the other reasons of your no fault is the withdrawal of the unit from the rental market. In all my 20 years of property management, this was never done, never removed unless it was extensive water damage. And in those incidents, 2 in the 20 years, they were given options, again, transfer to another vacant apartment at the same rental rate, or be put up at a hotel if there was no vacancy in the apartment complex. And repairing this water damage took just resolving the cause of the water damage and then removing the damaged walls, flooring, and carpeting, and possibly a few light fixtures.
So Ann, you have about 5 more seconds if you just want to wrap it up.
Yep, I said it all.
Okay, thank you. Awesome.
Mr. Mayor, can I ask City Attorney a question related to that last comment?
Yeah.
Okay, can you just explain the legal remedy if a landlord hypothetically says, hey, you got to get out, we're doing a 30-day remodel, and they change a light bulb, or they do something that's not really 30-day? How does the tenant, what does the tenant do in that situation?
Under 1482, the tenant's remedy is basically to use litigation to.
So they have to hire an attorney and, okay.
Exactly. And the court remedies could include, allowing the tenant to reoccupy at the previous rent, could include monetary compensation if they're already in a new lease, but basically the remedy is litigation.
Okay, thank you.
Since we're asking the attorney questions, that was mentioned in the previous comment from the apartment association about the COVID level restrictions that have gone in the last 2-3 years. I know the governor is with removing COVID emergency order by the end of this month. Do you know what that'll do for any of these existing rental protections that were put in temporarily? Or did I catch you off guard?
Oh, no, it's,
Oh.
I think this. It's a
Yeah.
hot discussion. I mean, there's active litigation involving the city of Oakland and
Oh.
county of Alameda locally about the continued implementation of their eviction moratorium.
In reference to COVID protections.
They enacted it related to COVID, but
Mhm.
they have not indicated that they intend to repeal those moratoria once the governor's order has been rescinded. So there's active litigation about both of those. But I think, since the council did say you'd like local information, and I'm looking to the city manager to remind me, I mean, the county imposed a temporary eviction moratorium, but it was very short and has long since expired. So within the Larkspur community, 1482 has been in place essentially since, well, at least since 2021.
No, we followed the county's eviction moratorium, so we kept matching it. So we essentially had the same moratorium in place, and since the sunset was September of last year, I think. Yeah, so that's essentially any data that would be relevant would be after that. I only was chuckling because I will say, if you're really interested in this topic, the LA Times is doing a nice job of covering it in Los Angeles, where it is the topic that I think in this arena right now is what will Los Angeles do.
So the comment about getting data, because I'm, as a science background, I'm data driven, that AB 1482, which was enacted in 2020, really hit a wall of really knowing the implementation of it because of that the cap that was put on based on the COVID emergency orders that came from the county and the state, correct?
Well, I think yes. I mean, short answer, yes. Slightly longer answer. I think we know because of the Skylark situation what it means, what it could mean because of the higher inflation rate. The formula under 1482 will allow rent increases, up to the 9% for given that window. Now that the inflation rates come down, the amount of potential increases has also gone down. But it is, I had forgotten that the county's eviction moratorium was in place for so long. So it is true that although the no fault evictions have been, the 1482 structure was in place beginning in 2020, the county's eviction moratorium has basically put a hold on the implementation of it.
Sorry, I gotta be wonkish for a second. Just remind the council, the eviction moratorium we're talking about was not, there shall be no evictions. It was, if you meet these criteria, you are not subject to an eviction. So it's quite possible there were evictions under the Tenant Protection Act in the last 2.5 years. We just don't have any way of really knowing that.
Okay, thank you. So any other public comment here in the chamber? Hey,
Hi, thank you very much for holding this and for separating it out. I really respect your effort to have concentrated focus on these topics.
Dorothy, you want to tell us your name?
Apparently you know it.
Okay,
My name's Dorothy O'Leary and I live at Skylark Apartments.
thank you. Yeah.
My understanding of the Ellis Act is that it is a provision which says that none of these no fault eviction rules apply if the landlord is, or the owner is in fact taking the property off the market. I don't know that there's any, like, for how long? Is it off the market for a week, a month? No. Is that just, are we on the honor system around that? I don't know. Is there any clarification you can offer me, Mr. City Manager?
So I'm not going to put myself out as an Ellis Act expert. My understanding is the state law is silent on this, and a number of jurisdictions, probably most prominently San Francisco locally, have adopted ordinances to try to limit the scope of it so that if it's ostensibly taken off the market, but then basically put back on within a locally determined period of time, then you do see things like either a tenant reimbursement requirement or a right to re-establish tenancy in the unit. But it's a locally driven limitation on the general provisions of the Ellis Act.
So what you're saying is the Ellis Act is something that needs to be addressed locally. And so that's what I put out to you, is to please consider that needs a lot of attention and strengthening, as does the rule around family member moving in or substantial remodel. These are things that really need to have definition. What does substantial mean? And I think that was addressed by a previous speaker. I also want to address the idea of fair compensation when a tenant is evicted at no fault of their own. 1 month's rent is not relocation money. You know, we all know that you need first month's, last month's deposit, and the expense of moving itself is expensive. So I'd like you to take that into consideration to people need at least 3 months rent, especially when it's all of a sudden thrown in your face and it wasn't a planned move. Again, I want to thank you so much for this opportunity. And I realize the need to separate these topics. However, I want to reinforce what you probably already know, I hope you do, which is that these two things cannot stand alone. Just because, as the city manager pointed out, it is legal for you to adopt one or the other, rent control or just cause eviction protections separately, one or the other. However, just because you can doesn't mean you should. And they are intrinsic to one another. So I ask that you please, please, please keep in mind that we need both.
Okay, thank you, Dora. Okay. Anybody else here? We have,
Just comment
And I was the subject of an Ellis Act eviction in San Francisco and was told that they had to keep it off the market for 10 years. So I just want to mention that.
Okay, thank you. All right, that was Ilana, right? Thank you, Ilana. Anybody else?
Hello again.
Hi.
My name's Jerome Burnell. I have the Blue Rock and Larkwood Apartments. I just want to say that as a landlord, landlords don't evict good people. They really only evict people if there's a problem. And I've never really done an eviction for any of the stated reasons, but it's a nice tool to have in my, my quiver, or an arrow in my quiver. I have had cases where somebody has been disruptive, caused a lot of noise, partying, playing music till 2 o'clock in the morning every night, fighting, smoking in a non-smoking building. Tenants on both sides of the particular tenant complained time and time again. I spoke to the tenant. Eventually, the 2 tenants moved out on either side. The person across the hall was ready to move out. I basically had to cut the cancer out and ask him to leave. If I had to serve the papers on that, it would take months and months to do it. Kevin, you're an attorney, this could take 12 months to evict somebody on an apartment. But with a no-fault eviction, I can just say, hey, you've got to move. And usually talking to them several times does it. But you really need that protection to be able to use that tool to say, hey, if you don't clean up your act, you're going to go. The only other comment I have, and I'll keep this short, is at the end when you're saying about if a building is condemned or has a problem, what happens if there's a major earthquake or a fire? Is the landlord responsible for paying, the tenant a month's rent or 3 months rent to move out, in addition to all the loss that he incurs on his property? So that's all I have to say.
Actually, if I could ask you a question, I had said before, I wanted to be transparent about what helps make a decision. So, Mr. Burnell, you're a landowner. So what I think you were describing was, at fault evictions. And I don't think, we're really, if someone violates a lease is what you were sounding like that example was, right? Someone was clearly in violation of the lease.
Yes, but you can't get it done because first of all, a tenant is not going to go to a court and testify against another tenant or even write a letter against them. I mean, it's not Germany 1939. For some reason, these people are next to them. I've never been able to get people to even put it on print that this person is causing noises, but they'll talk to me and they'll vote with their feet. They'll just move out. So on paper, it sounds really good. These ordinances are there, but in reality, it doesn't work that way.
Okay, that's fair. And just a second follow-up question, from the prior speaker, if say we went from, there isn't an issue like you're describing, but you need the unit for whatever reason, or you're doing substantial remodel. And right now you only are required to give 1 month's rent. Would 3 months rent be something that you think is really burdensome to the landlord community?
For myself, when I bought the building 30 years ago, I remodeled a lot of the units and I always gave the tenants a choice of moving it to another unit that was available. Some people moved up in unit and all the units aren't the same. They're all different. Some tenants moved up, some tenants moved down. Most of them stayed, but they wanted the improvements to the building. And I didn't have to really pay them anything like that. That was it. I gave them, like 2 months notice that I planned on doing their unit if they wanted to move ahead of time. That was possible. I think 3 months would be a bit excessive. 1 would be more realistic because people are going to get their security deposit back, especially for remodeling it. There's no reason you're going to charge them for something like that. There is no last month's rent. You can only charge 1.5 times the security. The rent is a security deposit and first month's rent. So you can't really charge a last month's rent per se.
Okay, thank you, sir.
Can I ask one question?
Sure.
And I know every landlord's different and I joked about wanting to move, having my grandson now and thinking I should be moving in, but on your security deposits, as the rents have gone up over the years with your long-term tenants, is their security deposit still what they paid 10 years ago or?
For myself, yes.
Whatever, because I've had both kinds of landlords, one that they never asked me for a dime more, but newer tenants were paying a much higher
No, for
rate.
good tenants, you don't want to lose a good tenant.
Yeah.
Because in
Yeah, so.
But legally, you can increase the security deposit.
could.
Well, that's not a,
Yeah.
you're not a lawyer. I'm not asking you for a legal opinion, but it's just, I know some landlords do, some don't. No,
Yeah,
I was
it's
curious.
just an individual thing. I mean, they're good landlords or bad landlords, just like tenants.
Yeah.
So that's the thing. So,
Thank you.
all right.
Great. Thank you, sir. Okay.
I did want to address one comment yes, in the scenario that the speaker asked about, if there's a natural disaster or occurrence, the act of God occurrence that results in condemnation of the building or a red tag that says it's not occupiable, that does trigger these provisions now in state law for the 1 month's rent compensation for relocation. And then you may have local ordinances that have a higher compensation.
Is there insurance available for landlords on something like that?
I don't know.
Yeah, no, it's just a
so,
question.
yeah.
Yeah.
Okay, great. Anybody else in the chamber? We're going to go to Zoom in a minute. I see 5 hands, and for those of you on Zoom, I am highly appreciative of your patience. We had to start late, and you've been listening, and it's been a lot of technical and a lot of our questions. Yes, ma'am. Actually, you already went, but we may be able to come back. I do want to see if there's anyone else who hasn't spoken first. Okay, and again, we will come back. So don't worry, you'll get your chance again. So Allison, if you don't mind, we'll start with the first person in Zoom.
First speaker will be Michael Burke.
Okay, welcome, Michael.
So, all right, can you hear me okay?
Yes, we can.
All right, thank you. I had originally, I'm very, my name is Michael Burke. I'm not a resident of Larkspur. I'm a real estate agent specializing in the sale of apartment buildings and have been so. Now this is my 50th year. So I'm represented many Larkspur apartment building owners through the years. I meant to talk tonight about I've been very involved with the Fairfax issue, and I meant to try to compare tonight with what's going on there, but that's just a suggestion. I'm not going to do so. I will keep my comments very brief. The state, of course, already has in place their version of the Just Cause Protection Act, AB 1482, the Tenant Protection Act of 2019. This goes a long way to addressing the issues. It was, however, put in place primarily to address rent gouging, the most severest of cases, and it worked very well. Unless Larkspur has documented several instances where existing statutes are abused, I would strongly suggest there's no need to fix that which is not broken. In the IJ this morning, a letter to the editor commented that Fairfax has found a solution. Now it's looking to try to find the problem. Fairfax addressed these 4 items and went way beyond these 4 items. They tried to close every possible loophole of these 4 itims, then they went further. Please leave these issues to be decided at a state level. There's nothing unique about any situation in Larkspur that warrants addressing it at a local level. And if for some reason you do decide to proceed, please learn from Fairfax. Put it up for a vote of the people. Do not enact it at the council level. Please. Thank you very much. Michael Burke.
Great. Thank you, Michael. Who's the next person, Allison?
Next speaker is Angela Mercado.
Welcome, Angela.
Hi, can you hear me, sir?
Yes, we can.
Okay, good evening, Mr. Mayor and members of the council. My name is Angela. I'm a 70-year-old single woman with custody of my 2 youngest grandchildren. They are 6 and 7. I am a resident of Bon Air. I have lived here since 1992. My mother was the rental manager here for 18 years. And recently, my roommate that I have lived with since 2010 retired and moved back to the Philippines. And when she gave her notice, I was told by the current rental manager that I had to come in and sign a notice to vacate and reapply to live here, even though I'm already approved and on a lease with my grandchildren. I received a call within a couple of days that I didn't qualify and that I was either going to have to get a roommate or move. And I can pay my rent. I pay my rent every month. And I went and consulted legal aid. and was told to rescind the notice to vacate they made me sign, which I did in writing, had it witnessed and dated, and delivered it in person. And then last week, I received a call from the manager here who told me that I couldn't live here because I couldn't afford it. And that after the rental raises of this year, I really wouldn't be able to afford it. And I said, but we've never had more than a certain amount of rental increase here, and because our buildings were built in 1941, so they are kind of protected by that 10% increase thing. And he told me they were going up a lot more this year and I wouldn't be able to afford it and it would price me out. So I had a week to move. That my rescinding of my notice to vacate was not legal and that I had to go. I I don't know what to do. I've consulted quite a few people and apparently he has no just cause to evict me because I pay my rent in full every month. I gave him my rent check on the 1st. He did not cash it. I know he's trying to get me out of here because my rent is very low compared to most people here. I've been here a very long time. And I understand that. It's not up to what they could get for this apartment. But I think the fact that I'm a good tenant, I don't make a lot of noise, I don't party. I take good care of the place. And I pay my rent in full and on time. And I think that that should have some bearing on my being able to stay here. I think I'm being discriminated against because of my income. And I don't think that's fair either. I don't know what to do except, you know, fight him on it. And he told me that if I didn't move, he would make it so I wouldn't be able to rent anywhere else. And I don't think that that's right either. I feel like I'm being bullied. And yes, I'm not rich. I don't make a lot of money, but I'm
So Angela, we're out of time. Maybe just one more sentence to wrap it up, please.
okay. I think that it's really important that you guys take into consideration that not everybody that lives in Larkspur is wealthy. And that some of us have been here a long time and we need to be considered as well, to be protected so that we can keep our home. We deserve good homes as well.
Great. Thank you. Thank you, Angela. Okay, Allison, next person, please.
Next speaker is Tristan.
Welcome,
Council.
Tristan.
Can you guys hear me there?
We can.
All right, perfect. So I just want to respond quickly to the gentleman that owns the Blue Rock. If it's a testament to him and all of Larkspur's other landlords that this hasn't been an issue before. And you know, everyone here at Skylark benefited from that as well. And the unfortunate part is that, you know, times have changed and the same thing that happened to the Pells will happen to these great landlords. And all we want to do is make sure that the conditions that we are used to, that being treated as people, is something that we can expect from landlords, not something that Larkspur is truly special about this place and an exception to the rule. To that point, just cause eviction protections are important because they close several loopholes that can be used to abuse tenants. I'll try and touch on the ones I think are most important. The right to return is actually a very neat little thing that solves quite a few issues with landlords using the Ellis Act to evict someone and then putting it back on the market. If they have to offer that to the last tenant that was there at the same rate they were paying before, that is a very good disincentive not to abuse that law. Same goes for abuses of construction or substantial remodels. So that is an extremely good disincentive to abuse that law if you have to offer this tenant the right to return. The other one that I think is important is especially important is the relocation payments. You know, considering that any new apartment that is found by the renter will require first and last month's rent, I think that conversation needs to start at 2 months. That is the floor. Landlords expect that from their tenants when they apply. And I think if a tenant is forced to move out through no fault of their own, they should at least be compensated in a similar manner. So the floor there really needs to be 2 months. And I would also like to point out that with the we want our families who grow up here to have stable households and the maximal success at school as possible. So I think the timing is a very important piece there, especially if the resident has a child enrolled at a local school. That is important for the long-term health of this community. And, you know, like I said at the beginning, that is something we have not had to worry about. Conditions have changed, and it is now something that the city council needs to worry about. So thank you so much for your time, and thank you for all your attention on this.
Great. Thank you, Tristan. Allison, who's the next person?
Next speaker is Vivian Taub.
Welcome, Vivian.
Hi, can you hear me?
We can hear you.
Okay, I've written something. I'll try to get through it all. I am in favor of strong just cause eviction protections because without them, rent stabilization would be meaningless. As a 61-year-old woman with a disability, I worry about the security of my current rental housing at Skylark. I am afraid I might be evicted arbitrarily because my landlord may want to renovate my apartment and charge higher rent to someone else. Just the thought of packing up all my stuff gives me anxiety after almost 15 years in my current apartment, which is by far the longest I've lived in one place. Tenants evicted due to no fault of their own deserve relocation payments that actually match the costs. I agree with Dorothy and Tristan on this, which actually far exceed that mandated by law. We need relocation payments of at least 3 or 4 months. Tenants evicted due to no fault of their own deserve a right to return to their former unit should it ever become available again at their former rent, plus any legal rent increases under rent control. Tenants who are elderly, disabled, terminally ill, educators, or students deserve additional protections. For example, owner move-in evictions should be extremely limited, if not prohibited, for such tenants. Seniors and those with disabilities and terminal illness should also receive higher relocation payments. As I understand it, this is already an ordinance in Fairfax. Ellis Act eviction loopholes need to be closed. Under state law, landlords can evict tenants if they wish to permanently remove the unit from the market. Without local protections, these so-called Ellis Act evictions can easily be abused to kick tenants out and then rent the unit again at a higher rate. This can be prevented by making landlords who attempt this within 2 years liable to displace tenants for triple damages, and by ensuring that tenants have a right to return for at least 5 years. I urge you to advance a local just cause evictions ordinance alongside rent stabilization that will truly meet the goal of protecting Larkspur renters and providing real housing security to half of Larkspur's population. And I want to thank you for holding this meeting and addressing this separately, because they're like two wings of a bird. They need to fly together. Thank you so much.
Great. Thank you, Vivian. Who's our next speaker, Allison?
Next speaker is Brian Jaffe.
Welcome, Brian.
Good evening, Mayor and Council. Thank you for all the time that you guys have put into this issue and all the surrounding issues. I'd be there in person, but I had to feed and put my kids to bed, but I'm glad I could join you later. I'll start off by saying I live in Larkspur. I currently own a home, but in the past I've been a renter. I've also been a landlord, and this issue is very important to me because I fundamentally just believe all people should deserve to have stable housing. As many speakers have said, but I'll reiterate, just cause eviction protections are part and parcel with rent control. You can't have rent control but leave open all these other ways of evicting someone. It won't have any teeth. And I'd also like to build on what someone else said, that there are good and bad landlords. But just like any laws we have, we're not really here to police the people who are behaving well. We don't have speeding, a speed limit on the freeway for people that drive 65. We have speed limits for people who drive 95. And so I don't find that argument to hold water, that we should sort of wait for there to be a huge problem before we try to put guardrails around this issue. Renters deserve security. They are in a position of much less power and financial stability than landlords. And in my opinion, the job of government is in large part to protect people who are the most vulnerable. So I'm not saying we should not care about what landlords want. Landlords are people, and most of them are good people. But I think if you're going to err on being more protective of one group or the other, we should be more protective of renters. And lastly, I'll close by talking about enforcement. Whatever you decide, someone's going to pick it apart and try to find ways around it. And so I just wanted to ask, as you consider how you're going to make the rules, also how are these going to be enforced? Is there going to be somebody at City Hall whose job it is to do this? Is that going to be a funded position? And I would caution against the remedy being the renter needs to take the landlord to court. The court systems are slow and expensive. And if someone is going through something as traumatic as being pushed out of their home and don't know where they're going to be going next, they probably don't have enough money to hire a lawyer. So just things to consider. And thank you again for really trying to tackle this series of important and difficult questions.
Great. Thank you, Brian. Allison, who's next?
Next speaker is Eva.
Welcome, Eva.
Thank you, Ava here. I just want to point out a couple things. Someone mentioned Ellis Act, 10 years in San Francisco. But we've seen landlords and property owners get around that in all sorts of ways. We've seen, it's really up to them being caught. And so you can evict the tenant and then turn it into an Airbnb, which is extremely profitable. And so that's one issue. And then I'd also point out that the 3 to 4 months, say the relocation payment is 3 to 4 months for like an elderly grandmother with 2 young children. And she's getting 3 to 4 months of her rent, which had remained, flat for a number of years. And now she's going to get, 1 month or 2 months or 3 to 4 months, but she's being kicked out into an environment where the rents have, more than quadrupled since she first started renting. And so that, relocation money is really meaningless. And compare it with the advantage that the landlord is gaining from evicting her. Now they can, do some cursory remodel, but because the way the market is now, they can really increase the rent. So, I think this is being viewed improperly as, don't give Granny too much money, because you wouldn't want to, tempt her to do something frivolous with the money. But, she's going to need every penny of that and more to survive. And is she even going to be able to rent once she's kicked out with this like $3,000 or $4,000? What is she going to be able to do with that money? Meanwhile, the person who enacted that eviction is laughing all the way to the bank, unfortunately. So, a lot of these issues, I think previous tenants said you really need to drill down on the specifics. These need to be watertight, and they really do, because otherwise it's just kind of virtue signaling, performative, and it creates all this tension without providing any really solid protection to renters. And lastly, I just want to point out quickly why this is so important. I do a lot of research on unhoused populations in Marin County. It's a massive problem with people being evicted, and the pain that accrues and the way these people suffer. It's obscene. So these people need to be protected.
Great. Thank you, Abe. Allison, who's next?
Next speaker is Kathleen Baylor.
Welcome, Catherine.
Kathleen, but thank you so much, Mayor. I live in Bon Air Apartments, and I'm not being evicted yet. I'm stressed out about it. I feel like I'm waiting for the other shoe to drop. I'm waiting for someone to find a reason to kick me out. I live in the same building as Angela Mercado, and I'm troubled by, you know, I have a question and maybe the attorney can answer it at some point. Can a tenant who pays their rent consistently on time, always, for years, decades, can they be kicked out? Just because, oh, they don't make enough money, what does that matter if the rent's always paid? So that's my one point. The second thing is my friend Angela has school-aged grandchildren that she is in custody of and has brought them a long way. They have gone through a lot of tough times as little kids, and she's stepped up and filled in. So to make them, they are thriving in the current school district. Kentfield School District is excellent. They're thriving. To pull them out and send them off on their way is an extreme disruption in their life, and I believe harmful. Also, timing. Can someone actually be given a week to vacate or be threatened to be taken to court? I think that's despicable. And I can't believe that it's true. Correct me if I'm wrong. And I'll just say that it's not really a secret that Bon Air is looking to renovate every last apartment. And it makes sense. It's a beautiful area right on the creek, great schools. They want to renovate. They want to charge higher rent. But there's decent, hardworking people, good people, great neighbors, conscientious, helpful Angela Mercado that are essentially just being threatened to get the hell out. Pardon my language. And I think it's just disgusting. And, you know, I might find myself on my way out after what I've just said, but I have a right to speak my mind. And I'm just speaking in on behalf of people like Angela. And I thank you for your time. And I apologize. I am getting quite emotional about it because I'm just so angry and I'm quite anxious. Honestly, I'm a little bit nervous about, you know, what could they find with me and ask me to leave? How, you know, how could that happen? So thank you for addressing this very important issue and for taking your time to do so. I appreciate it.
Great. Thank you, Kathleen. And I'm wondering if the city attorney could address, there seem to be two questions there.
Generally, we have to assume every landlord in the city of Larkspur is complying with the law. I strongly encourage the council to not speak to specific eviction situations that may or may not be occurring. I think that's a path we don't want to be down.
Okay. I mean, I was not going to ask about any apartment building, but the question of law, if someone is under AB 1482, if someone is paying rent, is there any reason?
Again, Mr. Mayor, you don't have the entirety of the record of an individual situation. And I actually, unless you order me to hand the mic to him, I don't really want the public record to be speculating at individual circumstances that we don't
fair
know.
enough. Understood. Okay, thank you. So who's our next speaker?
Next speaker is PJ Pfeffer.
Okay, welcome, PJ.
Hi, thank you, Council and Mayor. This is PJ Pfeffer speaking as a Marin County homeowner. I won't be too long because you had a lot of great comments from people in support of strong just cause eviction protections this evening. I wanted to reiterate the point that this really is about making sure evictions aren't used as a pretext to reset rents, and they really do go hand in hand. And we see how big of an issue this is in that in response to Fairfax, but in many jurisdictions, landlords are openly talking about how they will hold units off the market that are subject to rent control until they can reset them to market rates. That's why a lot of the right of return rules for Ellis Act removals go out to 10 years. The idea being maybe that's long enough to prevent any bad faith vacancies. And it really is worth a lot of money to landlords, depending on the area of the home. There have been splashy headlines in San Francisco about $400,000 plus buyout agreements for renters in rent controlled units. That's because the value to that landlord of getting that unit back up to market rate is worth more than $400,000. If it's worth that much in a buyout agreement, the landlord is very much incentivized to go through every effort they can to do some sort of eviction that prevents them from having to pay out such a buyout, even if there's no cause. I also wanted to quickly talk about the extent to which some of these protections shift the risk and the burdens of the landlord-tenant relationship, specifically when it comes to paying for temporary housing, when there's remodels or relocation payments. Generally, the landlord is the one getting a profit. This is a business for them. The rent payments are their revenue, and there's always risks involved in a business. Having to do a repair is one of those risks. Having to relocate your tenant is one of those risks. And I believe one of the council members asked this question earlier. There absolutely is landlord insurance. There's landlord insurance packages that provide for payments for lost rent during eviction processes. There's a whole sophisticated market set up.
PJ, we have about 5 seconds. If you can just wrap it up.
That's it. Thank you.
Okay, great. Thank you for closing it. Who's next, Allison?
Our next speaker is Charles DeBeloy.
Okay, welcome, Charles.
Hello, my name is Charles. I'm a part of the Marin County Youth Commission's Housing Subcommittee, which has a goal to improve, bring a youth voice to the housing discussion in Marin. And seeing as some of us are in Larkspur, I'm here to speak on behalf of this subcommittee to display our support for just cause and the importance of renters protection, because as youth, I'd say we have a unique perspective on what it's like to grow up with unstable housing environments, which some of the other public commenters mentioned. And in these unstable housing environments, or in such a county with such housing disparities, and we really see how it can impact our lives growing up, or really fundamentally change our lifestyle when there's no just cause when we get evicted. So we support, just wanted to say we support such legislature that works to help stabilize families and more people. Thank you.
Great. Thank you for your comment, Charles. Allison, anybody else in the queue?
There are no further commenters in the Zoom.
Okay. It looks like someone rushed for last call. 2 people for last call. Okay, go ahead.
Okay. Our next speaker is Gigi Dixon.
Welcome, Gigi.
Thank you. Hi, I'm Gigi Dixon, and I'm a landlord in Larkspur. And I would like to speak to the substantial rehabilitation of a property and what you mentioned earlier about considering whether tenants should be able to go back to the property at the same rental rate. Unfortunately for me, I have a triplex that it's been almost 4 years that I've been working on rehabilitating. Due to COVID, the length of time it took to get permits, supply chain issues, staff shortages, a bunch of other issues. And by the time that I'm finished, we will actually be underwater as far as we'll have more into this property than we could sell it for. And so if I had to go back to the tenants that lived there 4 years ago and offer it to them at the rental rates that they were then paying, and now they're getting practically a brand new building, we've had to do everything. That just would not work, and that would put us even more underwater. So I do want you to consider that when you decide how to address that issue. Thank you.
Great. Thank you, Gigi. Anybody else, Allison?
Looking for any additional raised hands from our Zoom audience members? There's no further public comment on Zoom.
Okay, so let's bring it back to the chamber for one last round. Yeah, well, why don't you let her go, and then if there's no one else. No, you can go ahead.
Good evening, council members, the mayor. This is just a question before I go into my public comment. Mr. Schwartz, I think the question And I appreciate you having explained how you came about, sending, mailing a mailer to the landlords and not the tenants. But I think the reason you were getting the public comments that you were getting is we felt that there's already a power imbalance, and clearly landlords would oppose this while the tenants would be for it. So it's a pretty impassioned discussion. So we felt that as tenants that we didn't get the same invitation, so to speak. And it's not the invitation per se, it's just the credit of getting a mailer in the mail, right? And I have two of my neighbors who they're not on social media, they don't have an email or anything like that. And the only way they get information is from me. So I think a mailer would have reached a lot more tenants. So maybe that's why you're hearing that. But what we thought
And
is.
Joki, if you could just address the council, we're hearing the comment if you're
Oh, sure.
talking
I'm
about,
so
yeah.
sorry. Yeah,
No, no problem.
absolutely. No worries at all.
Mhm.
So I think that's why I was just addressing it to him because he had asked the
Yeah,
question.
understood.
Yeah. So that's why I think you're hearing the comments that you got is because as tenants, it already takes a lot for us to come here and to actually speak and to express that. So we would just like to say if the notion, if what we're extending to the landlords is that the general public will be receiving that via electronic channels, then we think the landlords are part of the general public, correct? But in this situation, it looks as though they were set aside. They were not part of the general public. They were given a special mailer, but the tenants were considered part of the general public who didn't deserve a mailer. What they deserved was electronic purposes.
Mr. Mayor, I deserve to comment. I'm not going to allow a speaker to say I made choices about who deserves things.
Okay. fair enough.
And Mr.
I
City
made no
Manager,
such choice.
Mr. City Manager, it's not necessary. I mean, just.
Okay, Joki, actually, if you can, I think I brought this up earlier because I wanted to, and we can discuss it offline, but if you have a public comment about just cause evictions, that would be most appreciated.
Sure, and I'd love to discuss that offline if that's okay. Okay. Regarding the just cause, regarding the eviction protections, we wanted to state that state level eviction protections.
Dan, could you, I don't know, the clock's not going.
So, do you want it said again?
Yeah, let's just start now. It's fine. Go ahead.
Well,
Say that
sorry.
again?
I'm sorry, what was the question, Dan?
Well, it expired. I didn't know if you wanted me to.
It
start
expired.
over.
Oh, so the 3 minutes are up. Okay, so. Okay, so and Joki in the past said that you're representing a group, so the time is double. If you can just make your points on just cause, and why don't we start the clock? Go ahead.
Okay, sure, no worries. Thank you. The state level eviction protections are totally inadequate for keeping Larkspur renters in their homes and in their community. State law fails to provide any meaningful support for tenants who are evicted due to no fault of their own. They fail to protect vulnerable populations such as seniors, people with disabilities, the terminally ill, teachers, students, and they fail to close commonly exploited loopholes using the Ellis Act. So you've heard about the Ellis Act, you've heard about, there's four that I think are really important. Tenants who are evicted through no fault of their own deserve relocation payments that actually match the cost of the local relocation. And what we think is fair is between 3 to 4 months of local fair market. And of course, that's because when you move, you have to pay first and last months and a deposit. So we think that's fair. And then the other one that I think is really important is that tenants who are evicted due to no fault of their own deserve a right to return to their former unit should it ever again become available. And you've heard about this, but I wanted to just reiterate this because this is a really, really important one, because of course it makes common sense. A tenant is evicted from their home despite having done nothing wrong because a landlord has just cause. And usually the landlord has a reason to do that. They have just cause for eviction. That's fine and good. But then the tenants should be able to return to their home at their former rent plus any legal rent increases under rent control once that just cause is no longer applicable and the unit is back on the market. So what we've seen is that failure to establish a right of return will predictably result in landlords coming up with a just cause, evicting their tenant, and simply finding finding a new tenant to replace the first, because obviously they would get market rate. this is doubly true if the council passes rent stabilization, since eviction will be the easiest way for landlords to get around the rental gap. So what you've heard from other commenters today is that that's why the two of them go hand in hand. And I'll use Vivian's example that it's wings of a bird, they fly together. With one wing, you can't fly. And then the other one that I think is really important is that tenants who are elderly, disabled, terminally ill, educators and students deserve additional protections from evictions to ensure that their lives aren't upended by eviction. So in this situation, strong just cause eviction protections ought to place additional guardrails against displacement of our most vulnerable communities. And we haven't spoken about that enough today. And an example would be mandating that the tenants who are elderly or disabled receive a full year notice before they're subject to an Ellis Act eviction. And those seniors with disabilities and those who are terminally ill should also receive higher relocation payments to ensure that their relocation does not displace them from the community. Thank you very much.
Great. Thank you, Jyoti. Thanks for watching the time. Okay, anybody else in the chamber? Okay, one more round. Yeah, yes, sir.
Can we take 5?
Oh, I think this might be the last comment. Is that okay?
Oh, no, after the last.
After, yeah, then we'll take a short break. That's fair. It's been a lot of, okay, sure.
Sheila Faley, as I said before.
Welcome back.
I just wanted to thank you. I just wanted to add something from the discussions tonight of listening to all the tenants. It seems like most tenants that are unhappy, which are completely understandable, are coming from multi-unit buildings and properties, since they mentioned a few of them, the names. And it is completely understandable, their concerns, but also the opposite to that, there are landlords like myself and the gentleman that was here that maybe we have like 2 or 3 unit rental place. And if you make something really outrageous for, penalizing the landlords for whatever condition they might be in, then that would push these kind of landlords out of the market. I mean, they would have to sell, like the lady said, sell the properties, and actually that creates less place for people to live. So I just want to please ask you to be mindful of people that like us, which we don't do these things all the time at all. We try to keep our tenants. And it would be a great hardship if the relocation is, 3 or 4 times, whatever. However, it might be possible to set some kind of a provision, like, if you have restrictions, would be for a certain number of units of that building. If the building is a certain size, then, your restrictions could be more, limiting, I should say. Thank you very much.
Got it. Okay, got it, Gina. Thank you.
Gabe, before we take a break, can I just make one comment?
Sure.
I just want to make it clear on the record that the city manager explained the reasoning why we notified the landlords, that we have had meetings in the past and they have been mostly tenants. And we as a council wanted to hear from both tenants and property owners. As I had mentioned, to me, it's not the number of people who speak, but the quality of ideas that I hear. So because we weren't hearing from the property owners, I wanted to hear their perspective. So I completely support our staff's decision to send out those notices to the property owners so we could hear their perspective. If anybody was offended by that, it was not intentionally to emphasize one party over the other. It was just to help us hear from all interested parties. And I just wanted to just make it clear that I completely support our staff's decision.
Yeah, and I'd like to second that. So if there's no more, I think we've had about an hour and a half now. So why don't we close public comment and take a 5-minute break, and we'll come back and try to take the time that I mentioned earlier, which might be really helpful in getting to a decision, to open up and let the, council members exchange some views and see where we are in the process. So we'll be back in 5 minutes. Okay, so we're back in session, and we have closed public comment, and I'd like to bring the conversation back to the council. So any council member want to start off where we are and how we get to a decision? Please.
All right, so Mr. Mayor, let me recommend, and obviously you are the mayor, so you should be, you decide how we want to do this. One suggestion maybe to go through the different individual, if we want to start with the no fault evictions and see if we have consensus. I mean, we could, pick, go through them one at a time and see, hey, how does everybody feel about this? Do we feel this needs strengthening? Do we not? I mean, I'm not saying that we are going to do anything with any of this, but I think it might make sense to have narrower conversations than to have big picture, because I think we'd just be all over the place if we do a big picture conversation. That's just my thoughts.
I have a little bit of a different take on it in that I think the comment that 1482 was introduced in 2019, the end of 2019. And then we entered into 3 years of pandemic restrictions, which really flipped 1482, inability to really assess whether that existing law has results and protections for tenants, because it hasn't had enough time to actually be enacted. I mean, my question to the city attorney was, we are just exiting the state's mandate on COVID restrictions by the end of this month, although Marin County did in September of 2021. I'm not sure we've had enough time to really see whether 1482 is sufficient enough that we don't need to layer on additional things to it. And we may need to, but at this point, we don't have any data to support that. I felt like we heard a lot of public comment about, with a lot of hypotheticals of protections that we can build in, but I really didn't hear or hear from any tenants that found that they were having been evicted by a no fault of their own. I'm sure it probably exists out there, but are we trying to solve a problem that we haven't even heard is really a problem at this point? I'm not saying that we don't have an issue in the future going forward, but 1482 has really not had any time in which to really see substantive application of it. So I'm stuck in that realm. Particularly knowing that so many rental protections were enacted in an emergency setting in the last 3 years, which may have skewed exactly what our tenants are experiencing. So I'm not sure we're to the point where we even can add a layer onto things that we don't even know really happening. It's kind of where I am.
So just a quick comment. I think Councilmember Candel's point was about format.
Yeah.
And let's get back to that. And then I think your point was more general about, whether there's any, needed strengthening of provisions, to 1482. Maybe we can hear from the other two. And I'm sorry, City Manager.
I was going to build on a little bit on what the Vice Mayor said. I think something to bear in mind is, if you heard anything either tonight or in your own research, or that any aspect of this warrants follow-up, then we're going to do an ordinance, right? Then we have to get into what does it say. So it's because you may not find consensus by going through each one of these. You may disagree about the vulnerabilities under any one of the no fault provisions, but as long as there's consensus that all of you think there are vulnerabilities that you do want to address, I think we heard Catherine from Councilmember Way that she's prepared to wait to see how the state legislation plays out more. But anyway, my point was just, then you do have some level of consensus that we should continue to evaluate and study what your options are.
Okay, point well taken. Councilmember Hara or Carol, maybe
yeah.
we start generally here.
I can appreciate the concern about the effect of COVID on all this. But in the Concord situation, reading their report, I thought it was very enlightening, because they've had a 1 year and a 2 year report on how their program is going. And I found that very helpful. I don't really want to compare or even touch the Fairfax model, because one, it's much too recent, and two, the problems they're having are actually were referenced by the Concord people in a way. And that was what they found in their 2 years of the program. If you read through their report and talk to them personally, which I did, I reached out to two of the members of the ECHO organization, staff people who have actually worked with the tenants and the landlords and helped assemble that report. I talked to 2 tenant activists, and I could only find one landlord who was willing to talk rather openly about it. And what I found fascinating is that all of them, all 3 segments, agreed on the same point. And that was 90 to 95% of the landlords and the tenants are very good people who just didn't understand the law, particularly on the where they felt, and even the landlord, this particular landlord owns his own apartment complex and he manages 6 others. And he said his most difficult thing was not with the tenants, it was with the 6 other property owners, and explaining to them that tenants had certain rights under state and particularly federal law. They have a much bigger minority populations over there that don't necessarily speak English as their primary language. And so, including some of the property owners. And so there was a lot of misunderstandings of what actually exists. And that's part of the problem we're dealing with here, is it's so fragmented. There's federal law, there's state law, and then we're the ones who live with the situation. And there's no requirement. There's been a very strong mobile home park law for years. I think at least 30 years in California. And it's only now, starting this year, that managers and owners of the property have to take a class on the laws that govern running their property. And we don't have that for landlords yet. And hopefully we're not going to be the first to require it either. But I mean, it is a complex area, and people have not kept up with it. And they found that in their first year, already incidents of evictions have dropped in half after the second year. Part of that is COVID, but they all agreed, including the landlord, that the biggest problem was the lack of education on the part of both landlords and tenants as to what already exists. Be that as it may, I would rather have seen, rather than Fairfax, a report or a comparison to a city that has a much longer track record, that has a 2 or 3 or 4 year report. These problems existed before COVID. Certainly COVID has aggravated it, particularly with the passage of the law that some landlords, and this again is based on my conversations with these people, is once the state said, well, you could go up to 9 or 10%, a lot of landlords, not a lot, but a number of them took that as a starting pistol to say, oh, I'm going to start raising that amount and the maximum I absolutely can every year, because they're reading the writing on the wall, which is that tenants are getting more and more representation in the legislature. This year, for the first time, there's actually a rental caucus of legislators who are renters. That's never happened in the state of California before, that you've had that kind of a caucus. And the fact is given the cost of housing and the scarcity of housing and trying to protect agricultural lands, more and more of the buildings are going to be away from single family homes and into apartments or condos or smaller units. And we all have unique problems there. There's a fascinating report that was done yesterday that was presented to the County Board of Supervisors, which I highly recommend people look at. And it was a county report on aging in Marin County. And the numbers that we're facing in the next 10 years are very startling. The jump in it's toward the tail end of the baby boom population coming through. And it raises a lot of very disturbing questions about how we're going to handle the situation. Right now, I was kind of stunned to hear this, there's plenty of senior housing in Marin County. The problem is it's too expensive for the majority of the population of the county. And I hear this anecdotally all the time of people who, when they have to place a relative in a care facility, they're having to go 100, 200 miles away to find anything affordable. What we do have now, approximately 15% or more of the population that's going to be aging is going to be suffering from dementia and Alzheimer's. And we don't have enough facilities in the county or possibly in Northern California to handle even that segment of the population. So one of the big emphasis that we're all going to have to face is maybe providing more in-home support services for people that can't stay where they're living now. And that's a big aspect. So long way coming around is I think we do need renter protections that are stronger than what we have now. I would prefer to be basing it on communities that have a longer track record as to what works and doesn't work. I think I read through the Fairfax report and some of the things I do not agree with. I hope we're going to get through the process part of it. Well, I'll wait till the sections on it, but that's basically what I'm trying to frame it as, is we do have a problem. One of the letters from a landlord was, I don't understand why there's a problem, and yet that's why we're here. All the people that were here, if you look at the majority of the letters, we're here because there is a problem right now. And we can't wait to study it and to see what happens 3 years from now as a result of this law, because in the meantime, what's going to happen? Human beings that we've seen here in this meeting room, that we've heard from online, that have written us letters, have said they need help now. It would be nice to have a chance to study it, but they need help now. Imminently, in the next 2 to 3 months for some of these people. And so I really think we need to set up the protections, and they're not written in stone. If it's passed by the council, we can modify it if it becomes a burden on landlords, or if we see, for instance, I'm personally not in favor of any more restrictions on owner occupied units or duplexes or triplexes. I have a real problem with anything more severe on it. But if 5 years down the road, the next council sees that there is a problem, fine, they can enhance the law. The same thing applies to landlords. If they come back to us with a real problem with that ordinance, we can change it. If we go to the voters and enact it by initiative, we lose all that flexibility. I mean, on a lot of issues, I agree with having the voters decide, but the problem with this issue is it's immediate, and it would take away our flexibility to adjust it for either the benefit of tenants or the benefit of landlords if we don't take action as a council now. Thank you.
Oh, that was a lot.
Great. Thank you, Kevin. The other Kevin. I think we're doing opening statements here, and then we'll get back to format. I seems like, we're all coming at this a little differently, but I'd love to hear from everyone.
Well, thanks. I appreciate it. I'll try to be brief. I agree with my new colleague, Mr. Carroll, that to the extent that we identify problems, and I think we can do that, we don't really need to wait beyond the current time frame to do that. Having more data is good. Often it's helpful, often it's not particularly helpful. I think some of the decisions that we can make in this context, we can use our own good judgment about what is necessary and appropriate and equitable for our community without waiting. And I don't think waiting is something that serves much of a purpose. In terms of, well, one other point. I do think it's important to have something that takes advantage of the progress that the state has made on this issue and allow us to continue to rely upon what the state has accomplished in AB 1842, whatever the name of the number of the law is. And identify maybe some specific areas where we think that for our community, improvements can be made. I don't think it would be useful really to go down each and every provision in state law and say, well, what do you think about this? What do we think about that? I think it'd be more productive for us to using, I think, the Concord approach as a model, identifying those issues that we think really are most important to our community. And I think we have heard some commonality in the comments that we've received tonight on that subject. So as a matter of form, and as a matter of getting something done, I think it would be useful to maybe adopt that approach rather than something more elaborate. So.
Great, thank you. I'll just speak briefly also. I think that there is a problem. My concern for data, information, policy precedents is to understand how this applies to Larkspur and to see that we don't have any unintended consequences, losing inventory, rental inventory, or not having a safety net robust enough where some of the vulnerable people have spoken up are still not protected. I believe that what makes this harder is not just that AB 1482 was only passed a few years ago, but there was the distortion of COVID, but nobody's mentioned it really. There was the distortion of hyperinflation. So, inflation has already come down. I think those of you who suddenly paid 10% more, or maybe it was above, I think that's an enormous shock to the system. And that to me is why I'm here tonight. I also have, reached out to the landlords, and I know insurance has gone up sometimes as high as 30%, and they're not being compensated. I think that cantilevered surfaces with supply chain lumber failures, $250,000, there is another side. So I really appreciate that there seems to be some divergent thinking. I want to return to format. Councilmember Kendall said we go through point by point. I think that, given that it's already 9:15, okay, I was about to jump in the room. Given that it's 9:15, I hope we can end at 10. And what I propose is the staff's deck, the very last slide, looked at examples of issues that can be addressed locally. So one was amount of compensation to the tenant. And then if we go over to the Concord model, which Councilmember Harf just referred to, Concord has said that, they have a specific that we can get into a moment, but I think we could perhaps just discuss that. And some, like Councilmember Way, may say, look, we don't even need to go there. Others may say this is not enough, but I hope this gives us, something solid and simple enough so we can start to see what the consensus is, what the parameters for staff to look at for an ordinance might be. The second on the slide is timing. How much notice must be given. I think that might be worth looking at. The third and fourth, right of return and right of available alternative. I'm wondering if we can maybe just pick one and then go to also minimum lease terms, which is in the Concord model. So we could have 4 things to talk about. They've been brought up in the staff report. We've had adequate time to at least, or we've been given some warning. Does that sound like a approach that everybody is willing to take?
Well, can I come? Whoops, looks like he wants to say something first.
No, you go ahead.
2 points. I looked at the Concord thing. Thank you, Councilmember Carroll, for bringing it up. It's close to 125,000 residents live in Concord. It's a big city. I mean, big city in California is defined as 300,000 or more. So I would say it's a modest sized city. We're at 13,000 and less. I don't know if this provides us with a comparable municipality to compare ourselves to. Just saying that, because I was trying to really figure out what we are more comparative to. And I'm not, it's Fairfax, I don't think is who we're comparative to either.
Oh.
So the other sort of issue, I think before we get into specifics, I sort of want to put out there is this is a conversation we've been having about rent control and rent stabilization. Are we putting the cart before the horse with deciding on renter tenant protections and elaborating on 1482 if we have yet to make a decision on whether we are going to move down the channel of rent control? Because what we've been talking about them in workshop wise as two separate discussions, but they actually run parallel, as some of our speakers talked about, two wings of the same bird. I'm wondering if this is something we've done a great workshop and learned a lot about, but do we need to revisit rent control and stabilization, and this gets piggybacked with it? Or are we taking this separate? It doesn't feel right to me to take this separate without really coming to a firm decision on whether we're going to actually take our own ordinance and elaborate on what already exists in California law for rent control and rent stabilization, which we haven't decided yet. I mean, we've had a lot of workshops on it and we've had a lot of conversation, but we have yet to decide if we are moving in that way of an ordinance. This to me sits next to it as a partner ordinance, not as a standalone one. And I think that's where I'm feeling with this, that this one comes along with the other if we decide, and we have yet to decide if we're moving in that direction.
And if I could just add to that, I agree with what you're saying. And I think today we are not going to make any decisions. It is not on the agenda to make any decisions today. I think just as we, with the rental control ordinance, that we could talk about it and see where we are on this. My thought is it may be helpful, because we can't talk about this privately,
Right.
that we at least just take some time and just figure out where we all stand, so that, I mean, we've done this for the rent control part. We haven't done this for this. We could kick it down the road and say, you know what, let's wait until we decide on the rent control if we want to. And I'm okay with that if that's what everybody wants to do. But at some point, we're going to have this conversation between the five of us to kind of, so that was just,
Yeah.
I'm fine either way.
I mean, if we're looking at Concord as an example that was given here, they also have rent control. So a rental at tenant protection program goes in tandem with rent control. I'm not saying we shouldn't do it. I'm just saying I feel like we're putting the cart before the horse until we actually decide we are going to ask staff to craft an ordinance, and we're going to actually have a vote on rent control ordinance that we decide to, then tenant protection to me comes hand in hand with it.
And I'm sorry, just to just comment a little bit. My thought is that both of these already exist on the state level.
They do.
Right. So we may, as a council, say, you know what, the rent control by the state is fine.
We haven't
And
decided that
right,
yet.
we may, and we may say, but maybe this portion of it, we should strengthen a little bit. So it's possible for us not to have our own rent control, but yet still want to strengthen some of these good cause evictions if we choose to. I'm not saying that we have to, but that's an option that we have, because both of these exist on the state level. And our question is, do we want to tighten rent control? Do we want to tighten this? Do we want to do both? Do you want to do neither? So while I agree they're intertwined, I don't necessarily agree that is a prerequisite that we strengthen rent control in order to deal with this. And again, that's just my opinion on it.
But if, I mean, crafting ordinance wise, I mean, if we were to take and create our own ordinance, which is greater than the protections that the state law provides, we could at that same time also include rental protections for tenants. Because, okay, well, I've already said my point that I think they go parallel, because I think we're mixing the two issues. Anyway,
okay,
it's kind of where I am, because I think the bigger one that we've heard the most amount of real public comment on is really what our decision is about moving forward with the rent control ordinance. I think we've had a lot of comment today about rental protection in a hypothetical setting, with a few clear examples of people who are being impacted by issues within their tenancy. But we've definitely heard different comments about rent control and stabilization that takes a broader umbrella than tenant protections. That's where I am. And 125,000 in Concord is much bigger.
Can
place
I
than we
ask
are.
the city manager? It's been suggested, or at least what I'm hearing is that somehow we take a kind of a straw poll on whether we're going to proceed with rent stabilization, which I personally would not want to do tonight because that's not what was noticed to the public. And so even though it might be legal for us to take a straw poll on that, as is being suggested, I don't think it's fair to the public or the.
Wait, I didn't suggest a
I
straw
don't
poll.
think anybody suggested.
Well, no, but I
Suggested.
I was referring to tonight, and my understanding about tonight is what we were going to discuss was eviction protections. And that was the point, was to get to the staff so they know what information to use to craft an ordinance to bring back to us in the future when we are going to we're parallel tracking these two issues, was the way it was framed to me. And so that the purpose of tonight is that we do go through and give staff direction on what we want to see.
Well, that's one, my understanding, that's one potential option, but workshops are usually designed for fact finding and for discussion. Most of my experience with workshops is that it is not it doesn't lead itself necessarily to direction to staff to do certain, other than research and further analysis, it doesn't lead them into crafting ordinances. Has that been my experience with this?
It's kind of generally that's correct.
Yeah.
But it often is how we've crafted the particular staff report that dictates what we've made available. I think staff is sort of seeking some guidance if going back to my point about where I think you could look for some consensus, even if you're not yet ready to agree on any particular aspect of eviction protections, if you feel that I heard something that I'm interested in pursuing, then this conversation needs to continue and we need to then have dialogue to make sure we're getting you the information you want to help inform you to make a decision. If you didn't hear anything tonight that's caused you to feel that a local ordinance is something to explore, then we'll take that as our general direction. And we can continue that conversation and I can hear from each one of you some things that you particularly want me to go find. Couple comments, if I may,
Please.
Mr. Mayor.
Mm-hmm.
Just so ECHO's been referenced a lot tonight. That's one of the nonprofits I've mentioned in the past. They're very active. If folks go look them up, they're very active with East Bay and South Bay cities. And their bread and butter business that best I can tell that they started on was serving as an intermediary when tensions arose between tenants and landlords. I think they're kind of expanded and they're offering more of a whole host of services now. But that does create a data problem because if they've been intervening, then you don't really know if the ordinance is entirely what's produced the behaviors, right? It could be the intervention. And in fact, it's an argument that Marin might benefit from a stronger resource for its communities than the one we've set up now to help serve as a liaison to tenants and landlords. I do feel a little differently than I'm hearing the council discuss with respect to this issue versus the broader rent stabilization issue in terms of the scale and size of the cities, because I think for rent stabilization, you're really you're making a choice to interfere with government regulation in a market economy. And you have to weigh that, and you have to weigh the scale of that within the community. I think here you're talking about issues that are relevant, whether we only had one apartment building in town or we had 10,000 apartment buildings in town. The individual tenants are under the same circumstances with their landlord, regardless of how many of these buildings, how many of these circumstances we have in the community. So for this topic, eviction protections, I feel more comfortable that we can compare ourselves to any community with that and try to see if something they do is effective for us, because it's a question of whether we think that behavior is occurring in Larkspur and you want to address that particular behavior. That said, if I can find more communities that look a lot like us, then I'll certainly try to bring more of them to you. When we gave you Fairfax and Concord, it wasn't to illustrate volume of problem. It was to illustrate what I thought were two very distinct ordinances. The Fairfax one is a pretty extensive ordinance and addresses quite a bit of eviction protections in great detail. And the Concord one is certainly an ordinance, and all ordinances are detailed, but I think they drilled in on specific problems and they kept their focus very narrow. And part of it may be because they had a relationship with Echo that predated the ordinance. And so they had been doing more tenant landlord relations for a long time. They probably had a better handle on some of the specific things they wanted their ordinance to address. So I just offer that for some perspective as you go through the conversation.
Great.
And just one point I'd like to make to staff. You're faced with, and I've tried to do a lot of this. I'm not on any of the ad hoc committees, so I'm free to study whatever the heck I feel like it. And I do. And part of the problem in digging into this for people to understand is finding comparisons to city our size is very difficult because we don't have the staff to issue reports every year about these issues. And neither do the other cities that are our size. It's only when you get into the larger numbers that there's data available. It's very difficult for staff to provide us with this kind of information. So that's one of the reasons why I was going on Concord, is just because there's a study, and trying to find one for a city our size is next to impossible because you don't have the staff to dig it up. Thank you.
Fair enough. Councilor here, yeah.
Yeah, I don't want to interrupt anyone. Listening to this conversation reminds me of an admonition that our city manager has often made to us in the context of these discussions, which is we already have rent control here in Larkspur by virtue of state legislation. So the tenant protections, the eviction protections that we might consider would still be relevant to us now in light of the fact that there is already a rent control ordinance in place. So I don't have any qualms about providing some guidance to our city staff about what we would think would be appropriate based upon our assessment of the equities in light of what the state has already done, regardless of what we do on rent control. I have my own strong opinions about what we should do on rent control, and I've expressed those in the past, but I'm not going to get into that now. My point is, it would be, I think, helpful to staff to provide some guidance on eviction protections that would be available to us, regardless of what we do on rent stabilization. And have that teed up at whatever is the appropriate time for that to be teed up. But to provide guidance based upon what is before us tonight, I think is perfectly timely and appropriate.
Okay. Well, so I feel like, we've kind of done the rounds here. And my two thoughts are that, both the consensus and my own feeling is that there's severability here. So we, to go to the analogy of a wing, the two wings of a bird, we already have a bird in the air, and it's a question of, strengthening one or the other and in which order. So I'd like to proceed. And I also, my second thought is, as a city manager, use the term satisficing. I'm a data-driven person. I've been in science for much of my life, and it's frustrating not to have all the answers and to be asked to really, make a big decision, but we have to move forward. So what I propose is we start with the item, which is on the Concord, in the last slide, the amount of compensation to tenants. So, and I want to respect what you're saying, Councilmember Way. I mean, I understand that, there's hesitation, and I'll definitely, I think all of us will bear that in mind. But currently, AB 1482 says that if you're evicted, you get 1 month. I think we've heard a lot of comments tonight about why that's not a good idea, and comments why that may be good enough. And I would love to get, the council to stay on point. We're not talking about rent caps. what the merits are of 1482 and whether to strengthen or not. So since you kind of started the point by point thing, why don't you go?
All right, so
No.
And we're talking no fault.
Yeah, all right, so what I mentioned at the very beginning is that for me, it's not the number of people who have a point, it's the quality of the point. And there was one person who made a point which really I agree with. Well, there are a bunch I agreed with. One that really struck me as true is that in the situation where there's a remodel, and somebody is kicked out because of a remodel, they have to go find a new place. And they're given 1 month's rent. The point was that this person is probably leaving an under market valued unit because they're being kicked out to remodel it and bring it up to market value. So their rent is going to be low. Once they leave, they have to go find a market unit rent, which is going to be high. So the fact, even if you say, hey, we're going to give you back your security deposit and a month's rent, and you go to another place and say, oh, I have a security deposit and a month's rent, it's not apples to apples. It's not enough in that situation. And I'm isolating this to that specific situation when there's the reason to kick somebody out is because you want to remodel a unit, because I think that has potential for abuse. If you have a triplex and you're moving in your kid, I don't see that as the same situation as, we're redoing it so we can rent it out for more. So in that specific situation, I am leaning towards being in favor of having a higher amount that person should be compensated if they get kicked out for that reason. And related, and Mr. Mayor, I don't know if you want to combine these or keep them separate, in that specific situation, whether that person can come back or the right of an available alternative. Hey, if you're remodeling my unit, I'll take that one over there at the same price. Again, I see that as a viable synergy, but if you want to talk about them separately, I'm happy to. But how's that for a place to start?
So great. So we are talking about just the relocation assistance, the cash, but we'll get to right of return, and I'll note that remodel is an area you think has abuse, and we might want to strengthen that. Yeah, let's keep it simple, Councilmember
Well,
Way.
if you're talking Concord, you can look at what they did, that it's equal to 2 times the current monthly rent or $5,000. So they put a number out there. Is that whichever is greater?
If you feel it's clear, yeah. I mean, I personally have a question for staff, for information, but is that your point? Is that something that seems fair, or keep it at 1482?
I'm just putting it forward as an option that we were reviewing.
Okay.
I think the point that some of the people made, if this is the road we're going down, then that 1 month is probably not a reasonable amount to try to find a new place. But whether it's 5,000 or 2 months, if that's where you're going, if you're going to look at the program highlights for Concord, that's where they went.
Okay.
I would be in favor of the market rate, period.
But what is that?
What the market rate for instance, the way I see it is what we want to do, and hopefully, is that tenant would stay in Larkspur. And so I would say the market rate in Larkspur.
1 month at the market rate?
1 month, at least 1 month at the market rate, preferably
Okay.
2, in my opinion.
But
Let's go for first and last, and then it's up to the tenant whether they'll stay within Larkspur or not. That's one of the reasons I brought up the point with the Blue Rock owner is, there is that dynamic for the renter of are we encouraging them to stay in Larkspur or not? And that's where we don't compare well with Concord. Because bigger community, you have more opportunities. We have a much more restricted market here.
And then where do you, what criteria is market rate? I mean, where do you get the number? Is it from a data source?
The housing department here in Marin County keeps those numbers. They try.
They try.
I mean, they base it on, I'm not sure what they base it on, but they can come up with numbers. And I would prefer an authoritative,
That right.
you know.
I think what I would prefer is something a little bit more concrete. And I see the city manager has picked up the mic, but my thought is that's a very amorphous number that's going to require work and change. And we could do the research now and maybe we ask staff, hey, could you, look at a ratio of well, I guess you can't do that actually because everything's a different price, but we could approximate, whether if it's 2 times rent, if it's 3 times rent, whatever it happens to be, it's a very simple formula that everybody knows, everybody can follow. If it's market rate, every time somebody leaves a unit, they have to do the research and it's a little bit of an unknown and it just makes it a little bit less certain and more complicated. I think that's all.
So 2 thoughts. One, I'm hearing some general consensus so far that you're concerned about whether state law is adequate in this particular area. You may not be prepared to have consensus on what the local solution should be. So that's good. We're advancing the conversation in one respect. I also want to remind the council, we didn't talk about a lot tonight, but you're going to need a rental registry to manage one or both of these ordinances, and you'll have data you don't have now. So I think probably rather than market rate, we might evolve to looking at the rents of the last certain time period and what's the average for comparable units. And although that's work for your staff, in theory, we're going to have a dynamic database that we should be able to call that right out of pretty quickly. And in theory, it should be relatively up to date, probably more up to date than what the county is speculating with their data. So it's that tool, don't forget, is probably, if we put one of these ordinances in place, we'll be proposing that tool as well. So
I would point out, I did talk to Marin Housing, and the one thing they said, if you do a rental registry, they would like it so that landlords update it on a yearly basis as to what they have increased the rent in the previous year. They would find that data really helpful.
yeah, so I actually think that some of, going to your comment earlier, Council Carroll, the cities have been doing this a long time. I think all require annual updates with the filing, typically tied to a business license filing. So they get all that data at the same time. And I think that makes a lot of sense.
Councilmember Haroff, I think we're doing round robin here.
Not sure I know where we are.
We were discussing relocation assistance amounts, so
Yeah,
it sounds like 1 month is, AB 14.
And I would prefer, as Councilmember Vice Mayor Campbell said, is to keep it simple. I think that was basically your point, and have something concrete. And I think it should increase. And I heard several people, I think tonight, suggest bumping it from 1 month to 3 or 4 months. I'd be perfectly comfortable with either of those.
Okay.
But I think it should be increased, and I think that's basically the structure of by which it should be increased, an increase in the number of months.
Okay, great.
So I'm kind of confused. We're not we're asking for more data. We're asking for more information from you. Are we really crafting an ordinance now based on one workshop?
What I'm going to go away from this conversation is I heard a lot of feedback that 1 month that's in state law doesn't sound like enough. I haven't heard that and I don't think tonight you need to solve what you would do. I think that you've all agreed that state law might need an enhancement is the key decision tonight that you've made on that point. And I think what you're going to do is a conversation down the road. And frankly, it's going to be another public conversation. And when you're getting to that, remember tonight, we asked really generally of the public, what do you think? But if we start dialing in and saying these specific suggestions, we're going to get very different kind of comments from people that you'll need to hear. So you can make not just an informed choice by staff bringing you all the different examples we can find of what these numbers are around the state, but what your own community is going to tell you they think will work in Larkspur.
So we're talking about giving a spectrum with the existing 1492, 1482, I keep getting 82. 1492 was with Columbus Hill to Cedar Blue. That's what's in my head. It's we're talking, we're bringing to you and you're going to bring back to us the spectrum of options from keeping it at 1482 or adding 1 month, 2 months, 4 months, and then we're going to have further discussion about it.
So my takeaway is exactly that. I've heard 1 month doesn't seem to work. So what you now need, in my estimation, to have an informed
Examples.
conversation are the 20, 30, 40, whatever number of examples I can bring you of what's out there. And that's easy to collect data. I just need to have staff and I go look up what the different ordinances say and make a table for you. So that's great. So that's something we can now put together. For you.
I think that's helpful. I just don't want to mislead the public that I mean, it sounds like we're getting very concise and workshops tend to be much more of not a concise, we're doing X amount of months or X amount of market rate, much more generalized.
And I want to, and I'm sorry, I think public comment is closed, so I don't think we're allowed to get public comment at this point. So I apologize for that unless.
We'll have another option, it sounds like.
But what I want to also just throw out there, and I hate to complicate this, but there is the possibility that if we enact this, that is going to have the effect of raising rents because property owners are now going to say, you know what? I got to have enough money to pay this person 3 months rent if they leave. So I have to save that up. So I've got to, if I charge an extra, I got to raise the rent a little bit more so I can save that money up. So when they leave or if this comes up, I can pay them. So I just want to throw out there, it's every act. Well, every action, has a consequence when you mess with the free market. And I just want to throw out there that we're messing with the free market and it's going to have consequences. So, for whatever it's worth, I just want to make sure we're all aware of that and considering that when we're deciding how we want to move forward.
I am.
Okay, fair enough. So
On compensation, can I bring up one other issue
go
on
ahead.
it? And that is on the temporary relocation for less than 30 days or whatever it was. We have, again, this is a unique Larkspur problem. If, for instance, it's a single mom or grandmother with 2 young children and she has to move out for 20 days, the compensation for that, where does she move? We technically only have the Larkspur Marriott in our jurisdiction. The only other 2 places are Marin Suites, which I do believe they do less than 30-day rentals. So a lot of their stuff is 30 or more days. And then the Best Western Corte Madera is sort of convenient because you're going to have an issue for particularly parents with kids in school. You don't want to set the compensation level so they end up over on East Francisco and having to take 4 buses to get their kids to school, which, by the way, there are changes to Route 29 coming up that people should be aware of, which does affect Skylark Apartments. You won't have a bus directly outside your door, that bus anyway. So that is an issue I'd like to get some more information on as to how we're going to handle that dynamic and how much would it cost right now. I mean, those are not cheap places.
Yeah, I appreciate that idea, but when we create public policy, we don't create it for individual circumstances. We create it for a general population and general use and micromanaging where someone would go, whether they go to Marin Suites or some other place. I don't really think that's within our realm to do.
But I do think forcing children to miss school is something within.
That's something we can talk about, but whether.
And I'm only asking for information, not a decision.
Whether the city has a prerogative to decide where the tenant seeks alternative housing is not really part of our purview.
I did not say we would direct where people would stay. I'm just asking what the cost would be to give us an idea of being able to come up with a dollar amount that's fair compensation for temporary relocation.
Okay, fair enough. And I kind of want to bring it back to, what we're doing here. And I appreciate Councilmember Way's comment, this is a workshop, we're not deciding, the spitballing that we're doing isn't like we're writing an ordinance, but I thought this would serve the public because, we've been doing listening exercises and it's, transparency for you, the public, to see that we're obviously forming opinions and judgments, and they are very, for me at least, I'll speak, they're very likely to change. I really am thinking that these numbers may get different letters and different information and divergent views. And so I hope this is a feeling like productive to the public as well. Just to cap it off on my side, I think what Councilmember Carroll was saying, kind of goes to my core question is, on this issue of relocation, is 1 month enough? One question for staff is there a good way to understand the cost of relocation? If we could just know, like I'm wondering, and much of my thinking in some of these rental topics is as an employer of many years. And, there's a lot of employment law too, when there's a severability, closeout costs and stuff. And I often wonder, what is the cost for someone to, pick up their life and go somewhere else if a job suddenly closes or I lose a customer. And so I feel, the equity here is understanding in Marin, in this community, if there's some way to understand what relocation costs are. And if not, we're back to, kind of being without data. And the other point I'd like to say that I've really learned tonight is that even if we only do just cause changes to AB 1482, we get a rental registry, even if we left the cap alone. Is that correct? That was my understanding from what you said.
I would recommend that.
Okay.
But you can decide differently. I think it would be difficult to feel confident in the effectiveness of any ordinance you pass if you don't have a rental registry.
Okay.
Because you won't have local data to rely on to tell you it's working or not working.
Okay.
And so, so I think regardless, if you're going to pass one ordinance, two ordinances, whatever we end up doing, I'm going to recommend you put a rental registry in place with it. Because otherwise the future council and the future city manager will be totally speculating on whether it's actually done its job.
Okay, fair enough. Thank you. So looking at the time, it's already 10 of 10, and I do want to try to end at 10 o'clock. We're clearly not going to be able to discuss all the issues, but I think we were mentioning the timing, minimum lease term, that's in the Concord model. I propose we can discuss that another time. The right of return was brought up. That might be the next one to go to. The one that we didn't talk about, which I find may be interesting, is the whole notion of vulnerability. And I'll just go to the case of, someone who has their kids in school. And if we should strengthen 1482, if there's a family somewhere in Larkspur and, they have someone going to, Hall Middle School, is there anything that we should do for that provision? Because I got the sense that everyone on the council sort of nodded their head that that's something to consider. And there's many others that were brought up, illness, age, and whatnot. But I just think that category we probably don't have time for tonight, but I'd like to name it and see if we can maybe discuss it or just touch on it briefly, and then right of return. And with that, we probably will need to adjourn if we're going to stick to 10 o'clock. Unless you guys want to go over for a few minutes.
Can I comment on that?
Of course.
The only thing I want to bring up on that is again, the free market, and that if you have something in place where certain categories of people get benefits, which negatively affects the property owner, if you kick out person A, it's going to cost you $1,000. If you kick out person B, it's going to cost you $10,000. They're not going to rent the person B. Right. So I know the intention is to help people in certain circumstances, but the unintended consequence is you may make it harder for those people to find housing because they're going to be labeled as potential problems. And a landlord gets 3 applications, they're going to pick somebody else. I think that's just the reality.
Okay. And yeah, let's just go around on this one.
For what it's worth, I agree with that entirely.
Okay.
I think it creates inequities in the way we would be proceeding, and I would be very reluctant to go that direction.
Councilmember Carroll.
I like the school age restriction. And I know that there are some that also try to protect school employees. That is a class, particularly here in Marin. It's a real tough issue. And one I think a lot of parents struggle with when they're faced with other dilemmas, divorce being the number one, is who, trying to keep the kids in the same environment. It is extremely disruptive, particularly for special ed or kids with special needs, because starting that process all over again at a new school, it's not uncommon for it to take 3-4 months. So I do like the idea of protection for both school age children and school employees. I realize it does distort the market, but there are laws that protect families with children against rental discrimination. They already exist. So I don't think if some landlord is being very blatant about it, they can get caught on a federal level for that, and which is no small penalty to pay for doing that kind of behavior.
Okay, thank you. And Catherine?
Do you want to say something? You picked up. I'm not sure. I just think if we're going to decide that there's a certain, not class, but a certain category of individuals that should stand alone, then we should be consistent with perhaps what the county has put forward under the social vulnerability index. And they have within the Health and Human Services and within the aging index for Marin County, they've already looked at this issue of who are most vulnerable within our community, and perhaps we remain consistent with that in the social vulnerability index that's been adopted by the county. So I can get that data, I can get that information for you, that if we're going to do it, I think we should be consistent and not just come up hypothetically with who we think we should protect. We should be uniform in what the county has also outlined as our most vulnerable residents.
And the only thing that I would add is, I know we're not going to make a decision, but I would like for the council members or even the public who's in favor of this to please try to convince me that it's not going to backfire and cause these people to kind of be blackballed. And I know it's illegal federally if somebody's blatant, but people aren't blatant.
They're subtle.
It's done subtly, and we could end up hurting the people we're trying to help. And I just, for me to be in favor of this, somebody's going to have to convince me that that's not going to happen, or somehow these people are protected and it's not going to backfire. And I just I'm not convinced of that yet. That's my concern. So I'll just throw that out there.
Great. I really appreciate all these comments, and the consistency with the county sounds good. I'm inclined to, lean with Councilmember Carroll. It's something that's near and dear to my heart. I don't know about distorting the market, but I also know that the market I believe that the market for apartments in Larkspur is got an enormous number of families. So discriminating would be kind of hard, because you might cut out your very, customer, because a lot of them, you're not going to rent out a 3-4 bedroom unit to, someone by themselves so often. Nonetheless, I'm glad we touched on this, whatever, I don't know, city manager, if you feel there's enough clarity or direction or anything emerging from this particular topic, but it seemed to be one that has woven itself into many of the public comments, and I just wanted to kind of, put some light on it. Yeah, please.
I think as we build you a table, I'll try to identify for you ordinances that have called out vulnerable populations, so you can see what they've done and you can decide if that's a fit for Larkspur.
Great, appreciate it. And the last one is right of return. There was a lot of discussion about that, and the Ellis Act was a part of that, whether that's used as a loophole or even, what is a substantial remodel and the request for clear definition. So same way we've been doing this with 3 minutes left till 10, just a sense of what we might want to get from staff or where people are. Councilmember
Mr.
Harrell.
Mayor, I would very much like to see a range of options on right of return. I think it's an important issue for us to address in this context. I don't know exactly what that means in terms of specific requirements. But I think we've had a number of issues we've addressed tonight where we're going to be looking for some additional guidance from the city manager and staff. I think this is one of those issues that we should definitely include in that category.
Okay.
I think, again, good point is that, like Catherine's point about the county already coming up with a list, what have other people done? You know, what's the more commonality? Because I would assume it's based on a rational, well, this is California, I shouldn't say that. In other words, real estate accounting is a very complex field. A landlord can have an empty unit and it's a tax write-off. It actually can be beneficial in a way to a landlord, but to a tenant, you're on the street. And that's the reality of life. So I would hope that there's somebody has figured out at what point, 5 years, 10 years, that it becomes uneconomical for a landlord to take that kind of an action, to withdraw from the market for that period of time and then bring it back on at a set point that they know they're going to start making, you know, it's economically better for them to make that decision is what I'm getting at, I guess. Excuse me.
I suspect just based on my preliminary research, that we're going to find there's probably, for cities that have a rate of return, there's probably quite a few that have said it's a year, quite a few that have said it's 6 months, and it's going to feel a little arbitrary at the end of the day, and not have a lot of thought process behind it other than, well, that's what the other guy did. In fact, a couple of the staff reports I liked quite a bit because they were very honest and upfront that they saw what the city next door did, so they just decided that must be a good idea and adopted the same thing. That's at least been pretty honest that that's the level of analysis that was done. But we can try to collect some of that. I think the challenge with the right of return, if you make it go too long, that I've seen some criticism about, that I'll put out as food for thought, is it may serve as a disincentive to invest in the unit if you know you're not going to have a path to recoup your investment. So that is consistent with some of the other concerns you've been voicing that we'll have to wrestle with.
Yeah, but it's not a reason not to do it. It's just a
I
reason to
agree.
do it right.
I agree.
Well, so, Mr. Mayor, can
Yeah,
I-
please.
So my concern with that is also the incentive that you're setting up, and it's something that we should think about, and maybe it's not a problem, but we should at least make an informed and purposeful decision that if we do that, we are going to be incentivizing property owners not to fix up their units. And maybe that's something that we want. Maybe if somebody is living in a unit for 20 years, they would rather have it not fixed up and have the rent stay low than fixing it up and have the rent increased. But and that may be our decision, but we should be aware that that's the choice that we would be making. If we say, if a landlord fixes up the unit and has to rent it out at the same price, they're not going to fix it up.
Right, we had a caller who has the triplex who said it's taken 4 years to upgrade her unit because of COVID and supply chain and permits and all the other things. 4 years is a long time to not have rent come through. And if their rent was X amount after 4 years and the improvements that they put in, how can they return a tenant in at X amount? I just don't know how we can say that that's equitable to the property owner either. So if they come back in at X amount, even though it's X plus 100, that property owner had to put in to the triplex, why would they rent again to an individual?
Well, I think that would be addressed in a rent stabilization ordinance that allowed a landlord to come before a board with an exceptional circumstance
So they go ahead
that they
and
needed to have addressed, and it would be handled that way.
But
Can I ask a question about as far as process, because I know we're over time.
Mhm.
Is our agenda really heavy for the 15th? And could we have a further discussion if the meeting is
I think your agenda is sufficiently light. If you want to continue this conversation, it's not enough time for me to produce a whole lot of information for you.
Yeah,
So
but
that,
I think we have a number of other points it seems that the mayor would like us to opine.
Yeah, and I mean, it is 10:03 now, and I'll just, one more minute if anybody wants to say anything, but I believe if we agendize these things, and I'm hoping the public finds this productive. I find this extremely helpful for me, and I hope staff too. We can try to limit it as well to 30 or 45 minutes, to just continue the discussion.
as an alternative suggestion that would give us more time, we've been trying to manage the agenda so that March would be a month where you could roll your sleeves up on a lot of these issues, and that would buy me a little more time to collect some information for everyone. I can't guarantee that because stuff comes up, but we've been trying to keep the March agendas fairly light, anticipating that you were going to work on these particular issues.
Mr. City Manager, if I remember correctly, we have a March deadline to decide about the moving the city offices because there's the financial incentive.
The one big issue is that one.
Okay.
Yeah, it's the only one I can't really pull out of March, but and so I won't schedule the really heavy lifting conversation for that night.
Well, I think it's also valid that we've had, 8, 10 meetings in this conversation that we can also, with all due respect to the public comment, we can also very limit that so that we can continue to have a more robust conversation. I mean, we had an hour and a half of public comment tonight, which is terrific. I mean, if we can also come up with a way in which we can just honor that comment has been very relevant to us and then have more time to engage with this type of conversation.
And the public would have at least 2 opportunities once an ordinance is crafted for further comment on very specific items that we may or may not include.
Yeah, I think now that I'm hearing there's interest in continuing to work on this topic, unlike the rent stabilization where I've emphasized a lot, I really need that key decision or key 3 decisions if Sky and I are going to be able to write something for you. For the eviction protections, we can almost build you a fill in the blank type of situation, because as long as I hear you say, well, I'm interested in exploring having the rent relocation cost be more than 1 month's rent, that's a simple thing to write. Okay, what should it be? Fill in the blank, and then give you some data and you can hash out what it should be. We'll give you some thoughts as we go through it, but it'll be a little easier, I think, to guide you through the minutia once we start moving down that path.
Yeah.
Mr. Mayor, can I have one last comment? 'Cause I know we're wrapping it up.
Okay.
One thing we didn't get to that I wanted to is the right to an available alternative. And I just want to throw out there that I know a lot of the comments were for smaller triplexes and things like that, that this would be overly burdensome in some ways. This would be one way that it would, by its very nature, be less burdensome to smaller properties, but would be more effective for larger properties. And it would also serve as a disincentive for somebody in a larger property to have bad faith evictions in order to jack up the rent, because they're just going to have to put them in another unit at the same rent. So it may be something to consider. I don't know if I'm directing staff to do anything. I just want to throw out there.
I was only going to add, I agree with the points you're making, but we didn't tackle tonight. I didn't put a big spotlight on it, but certainly one of the things that has caused considerable discussion elsewhere is addressing whether you want to take away some of the exemptions, right? So some communities are choosing to apply these rules to units that the state chose not to apply them to. And you'll at some point have to have that discussion. Some of the folks you're hearing from may have units that are actually exempted under state law. And if you don't touch that particular provision, then some of that discussion may go away, just because those particular concerns are not applied.
Yeah, so as a wrap, we touched on relocation assistance, 1 month or more. The, vulnerable populations and the right of return. The ones that I had for, either next council meeting or March is what you mentioned, the right of available unit. And I think in my notes was the same, the applicability of unit size. Are we talking about ADUs? Are we talking about 2, 4-plex, 3-plex? The timing of eviction, how much notice is given, and the lease term, 6 or 12 months. So I see 4 more issues, maybe more, but those were, tabled for today. But we are at 10:08, and I really appreciate everybody, those of you on Zoom, those of you here. Please, for me at least, I'd like to say you've heard some, formulations, some ideas. I'm always looking for input, emails. You've heard Councilmember Candell. He's looking for someone to convince him on issues. So, we really are trying to make this a conversation, and we're really trying to make this something that's a compromise solution, something where, we really are benefiting the community, the public good. So with that, I'm grateful to staff and grateful to all of you here tonight, and we are adjourned. Thank you.